seats, please. Please rise. The Justice of the Appellate Division, Supreme Court, First Department. He, all persons having business with the Appellate Division, draw near, give your attendance, and you shall be heard.
Oh, full house. Good afternoon, everyone. Welcome to the First Department. Based on my notes here, we have about 6 hours of requested time that takes us to 8 o'clock tonight. Not sure you want to be here that late, but again, the red light's for you, not for us. We've read your briefs, we understand your appeals, so ask for the time that you believe you need to get your point across. That said, first case up is People versus Willie Stooks.
Good afternoon, respondent request 5 minutes.
5, 2, and 5. Thank you. Off to a great start. Next case, 18 West 55th versus Pleaders House. I'm sorry? 5 and 2. I'll give you 5. Thank you. All right. Next case is Andrea S versus Paul Y.
Rhea Friedman for appellant requests 5 minutes.
5 and 3.
Respondent is yes, 3 minutes.
Is there anyone here for the children, attorney for the child? So 5 and 3 and what? I'm sorry? You said 3? Okay, 5 and 3 and 3. Thank you. Jewish Press versus New York City Department of Finance.
Good afternoon, Your Honors. Appellant Jewish Press, 5 and 3, please.
Thank you.
Respondents.
Oh, no, you're on both. 5 and 3 and 5.
Thank you.
Thank you. Ren Inc. versus Taylor Phrase Capital. Hold on 1 second. Please sit down. Santana. Oh, thank you. I have great wing persons. Santana versus Patel.
Respondent requests 5.
5, 2, and 5. Thank you. Now we get to Ren Inc. versus Taylor Freeze Capital. Okay, terrific. Welcome.
Your Honor, it's on behalf of the appellant. In this case, is appeal and cross appeal.
I got that.
So I request
5 and 3.
Your Honor, Albert Myers for Taylor Capital Markets LLC,
5 and 3. Thank you. 5 and 3. 5 and 3. Thank you. People versus Amadou Zubidi. 5 and 2. 5 and 2 and 5. Thank you. Chry versus Terrace on the Park.
Good afternoon. Plaintiff appellant 4 and 2, please, Your Honor.
4 and 2.
Defendants, respondent appellant, requests 5 and 2.
You represent.
Have respondents here?
Wait, hold on. Before you ask that question, let's focus on you first, okay? You represent Terrace on the Park and Glenwood Construction?
That is correct.
Okay, so
My firm was at last week.
that's fine. And how much time you need?
5 and 2.
5 and 2. There is no respondent here, which is Covco, I think, Covco Roofing. That's a real interesting situation.
If they don't show up, you want to ask for just 3 minutes then for plaintiff appellant?
Yeah, 3 minutes then for the plaintiff appellant. Same with you?
That is fine, Your Honor.
3 minutes, all right. That's so strange. Okay. Okay. Next case, Hudson Meridian versus Bayport Construction. You're here by yourself. You want to submit? I'll give you 3 minutes. Okay. A little apprehensive there, huh? Marianne L. versus Thomas L. That's submitted. Yang versus Pagan Law Firm. 5, 3, and 5, thank you. 318 West 15th Street versus 320 West 15. Which appellant are you? Yeah, don't mix that up, okay? You're 320, right? Okay, you want how much time? 5 and 3. 5 and 3. 5 minutes, great. 5, 3, 5, 3, and 5, thank you. People versus Jacob Leon. 4 and 1. 3 minutes, thank you. Shao versus Jiang is submitted. 15 in the case, Londell Davis versus Clennon. 5 and, I'm sorry? 5 and 3. Oh, which respondent? Okay, so I'll give you, you want, I'm sorry, 5 and 3 and 5? Okay, got it. Thank you. Okay, that's it. We're good. First case up, People versus Willie Stooks.
Good afternoon, Your Honors. I'm Benjamin Weiner on behalf of the appellant Willie Stooks. It is undisputed in this case that the court below denied Mr. Stooks' request for a new attorney without asking him or his counsel a single question.
Well, it was really a reassignment of attorney, right? I mean, that's what he filled out that form, right? It wasn't really, is that correct, or am I missing something?
I believe that is the word that was used on the form.
Reassignment.
Yes, he wanted a new attorney. I think it's quite clear that he wanted new counsel. That's what everybody,
I'm sorry, client, counsel. Your client filled out a form in requesting such reassignment. Other than the check-off areas, was there any specific reason why the reassignment was requested?
No, Your Honor, but this was
And is that a problem?
not in this case, Your Honor. And I think the key distinction between this case and People versus Porto is counsel's attitude. Counsel in this case explicitly asked the court to address the matter more fully and told the court, you haven't addressed the matter until at least you've heard from me. This suggested at least the possibility of a serious breakdown in communication that would have required a substitution of counsel. By contrast, in Porto, the court actually heard from defense counsel who reassured the court, nothing to see here. Everything's okay. There's no conflict between me and my client. And that is a critical distinction. I would also point out with respect to the forms themselves, they were different. The form in Porto had a blank space where Mr. Porto could have and chose not to elaborate his claims. This suggested that he couldn't have done so if he had been given an opportunity to do that on the record. In this case,
The effect of the waiver of the right to appeal on this issue.
there is no effect in this case for two reasons. First of all, this claim goes to the voluntariness of the guilty plea, and so it survives even a valid
How does it go to the voluntariness? Because my understanding is that the defendant, despite the fact that there was an opportunity for the defendant to either withdraw his plea or to make some kind of a motion, none of that happened.
Well, Your Honor, I
And
think
in fact, if I could add, during the allocution, I believe that the lower court asked the defendant whether he was satisfied with the attorney's representation, and he said yes. He was also asked whether he was being forced to plead guilty, and he said no.
that's all correct, Your Honor, but again, there was no reason for Mr. Stooks to repeat at that point his dissatisfaction with counsel, having had his request already summarily denied.
When you say summarily, I'm sorry, there was a written decision on his request, right? What was summarily denied was the attorney's wanting to explain the attorney's position.
That's, I suppose, correct. There was a written decision here, which shows just how serious this request was.
There's also a distinction, if I recall here, that the issue about the reassignment of attorney came up before the 7:30 hearing, correct?
That's right, Your
Right.
Honor.
And that when it came to the voluntariness to the plea proceeding, counsel never raised again the issue of the reassignment of counsel. Is that correct also? In other words, I'm thinking there's two separate proceedings going on. One is the 7:30 hearing where there's this call for the judge to have a hearing on the reassignment of counsel, but when we get to the plea portion of this proceeding, no issues raised. There were no more, it's as if at that point.
That's right. The issue wasn't raised again at the time Mr. Stooks.
And you think that's fatal?
No, it's
Why
not,
not?
Your Honor. Because
Of course, the court's not aware of it at that point. The court's thinking it was primarily based on the 7:30 issues, counsel representing the defendant with respect to the 7:30. But when it came to the plea, court's doesn't hear any more complaints about representation, or at least.
Again, because the court failed to conduct a sides inquiry here, there remained the possibility of a conflict that was still in operation at the time of the guilty plea.
We don't know that because it wasn't raised again.
In any event, this was not a valid plea waiver. The court here failed to explain the most critical part of the appeal waiver, that it was separate and distinct from the trial rights in the sense that—
You make great hay of the fact that the word separated was used instead of the word separate, and that the term about, ordinarily retain the rights. So can you elaborate on why the absence of the addition of a D is so critical?
I think that's not precisely, Your Honor, what we're arguing. The reason why the appeal waiver is invalid is because the court didn't explain that ordinarily a person would retain the right to appeal even after pleading guilty. That is how an appeal waiver is separate and distinct from the rights that are automatically forfeited by a guilty plea.
That is supposed to be followed?
I'm sorry, Your Honor.
Is there a litany that should have been followed?
No, Your Honor. But
You can think about that on rebuttal. Thank you.
thank you, Your Honors.
May it please the court. Good afternoon. Larry Glasser for the respondent, people of the state of New York.
Let's assume that the trial court's refusal to hear counsel out was error.
Yes.
What's the effect on the proceeding?
Well, I would say two of them, Your Honor. If that was error, which I would submit it is not, first of all, it is precluded by the defendant's valid waiver of his right to appeal. And second of all—
You heard your adversary say that that error goes to the voluntariness of the plea. What do you say to that?
I would disagree because, as Your Honor had said, at the separate plea proceeding, it's not that the defendant remained silent and didn't bring up the issue again. He affirmatively answered questions in a way that contradicted his prior claims. The court asked him, are you voluntarily pleading guilty? He said yes. Are you satisfied with your attorney? He said yes. He didn't just remain silent in lieu of raising what he thought would be a fruitless claim to re-raise. He affirmatively gave different answers. And more importantly, something very important happened at the start of the plea proceeding, which I'd like to draw the court's attention to. The trial court asked the people if there was a plea offer, and the people said it was 30 to life. And then the trial court turned to the defense counsel and asked the defendant's position. Defense counsel didn't ask for anything on his own. Defense counsel said something to the effect of, my client tells me he would take 25 to life. And the people thought about it and offered that 25 to life. So again, that shows that regardless of whether there had been a problem before, as of the time of plea, defendant and defense counsel had been communicating. They had discussed a possible resolution on the case. Defense counsel represented his client by asking for the plea offer that the defendant had wanted, and the people agreed to that. And then again, the defendant had said that he was satisfied with his attorney. Frankly, as he should be, considering the facts of this case, where he shot 3 people over the course of 12 hours and killed 2 of them, 25 to life was a very generous resolution to the
There
case.
was a 7:30 examination here where I think both psychiatrists found that the defendant had been malingering.
Yes.
They also found that the defendant's choice not to speak to counsel was a choice rather than something that was due to mental illness. How does that play into this, if at all?
Your Honor, I think that's very significant in this because in Porto, as is in the briefs, the Court of Appeals had said that a trial court does not need to inquire every time there's a request for new counsel. They need to require when there's a seemingly serious request. And in Linares, the Court of Appeals said that substitution of counsel is not the reward for truculence and delay. It is to address significant problems. So here, defendant's argument fails to put the defendant's motion in context, which is that this case had ground to a halt for more than 2 years because the defendant chose not to speak to his attorney, to the point where the attorney asked for psychiatric examinations. And 2 different examinations in 2016 found the defendant was malingering and choosing not to communicate with his attorney. And there was no reason he could not volitionally participate and communicate with his attorney if he wanted to. 2 more examinations in 2017 reached the same result. The doctors found that the defendant was discussing his case with clinicians and personnel at Rikers Island. He was just choosing not to talk to his lawyer. Actual cognitive testing in 2018 further showed he was malingering and not answering questions intentionally. And then when the judge...
Also, I think you started off by saying that, in answering my proposition, that you didn't think that the court committed error by not hearing counsel out.
Yes.
Why is that?
Because in the context, in the context of what I just recounted, 3 years of history of psychiatric reports, the court had this information. The court
had information, right?
Yes.
But the court didn't know what counsel was going to say. And the way that I read the transcript, counsel was pretty insistent, and the court shut him down.
Well, but again, counsel had been saying for years, my client's not talking to me. That was the basis of the case grinding to a halt. What the court had, because normally a court does not know the communications between an attorney and the defendant. So if someone raises a concern, the court doesn't have a factual basis. Here, the court knew because counsel had been saying, my client's not talking to me, but the court also had the reports that showed that it was the defendant's volitional choice. Then on the eve of this 7:30 hearing, when the people were going to and did present evidence to the court that the defendant was malingering and that there was no legitimate reason he could not communicate with his attorney, on the eve of this hearing, the defendant brought the motion saying, no, wait, it's my lawyer who won't talk to me. And the court was right to note that for the past 2 years, the defendant was in court next to his counsel, and counsel made these claims when the 7:30 exams were ordered, when the results came into the court. And only on the eve of the hearing did the defendant bring this up. So in the full context of this case, Your Honors, this is not a seemingly serious request because of the totality of the circumstances known to the court.
Thank you.
Thank you all.
Your Honors, I just want to draw a distinction between the purpose of a 7:30 hearing and the 7:30 hearing in this case and the sides inquiry, because I think it's really critical. The question at the 7:30 exam was whether Mr. Stooks...
You're critical in both junctures. You have an attorney that represents your client in both sides of the equation, right? I mean, whether it's a 7:30 or whether it's a plea, it's the attorney that's representing the client, and it's the quality of that representation that's at stake, correct?
The question is whether there is a serious enough conflict to require substitution of counsel under sides. And the court could only answer that question, as sides makes very clear, by doing a minimal inquiry, not an extensive inquiry, but a minimal inquiry, to ask Mr. Stooks and ask his attorney what's going on. That didn't happen during the 7:30 exam.
As Justice Rodriguez was pointing out, so assuming that correct, that there was error to not have the hearing for the 7:30 situation, correct? Again, now you're at the plea stage and not raising it. I would think that whatever quality of representation was affecting that representation at the time of the 7:30 had to carry over to the plea portion, right? It's not like it's not like they're not connected. It's the same attorney, right? So that at the plea, when you talk about the voluntariness of the plea, there's no indication to the court at that point that there's the continuing quality issues were still existing.
Well, I want to direct your honors to page 8 of our reply brief. We cite a number of conflict of interest cases, very
Answer
similar
my question.
issues.
I'm just, I appreciate what you're saying, but that, I'm just drawing that whatever the whatever the challenge qualifications at one point of the proceeding, that's got to continue to the next, right? It doesn't disappear.
I think that's precisely our point, is that the court never found out, because it never did a sides inquiry, whether there was a conflict. And that conflict, if it existed, would have carried through to the plea proceedings. And because there was no sides inquiry, that possibility of the conflict was in play at the time of the guilty plea, which is why reversal is required.
Thank you very much. Thank you.
Thank you, Your Honor.
18 West 55th versus Plater's House.
May it please the court, Alex Banzhaf from Tuttle Yick on behalf of the appellant. We've appealed a number of issues of the court-ordered license in this case, but I'm going to
Am I
focus.
correct that 18 stories of this building is up already?
Yes, it is. I'm going to focus my arguments here.
And is it the back side or the front side that we have a problem with in terms of the protective scaffolding?
In terms of the terrace protections?
Yes.
The backside.
The back side.
Yes.
The building is up already, right?
Yes, it
At
is.
the time, okay.
And the retractable roof is on what side of the building?
On that side, you can see a picture of it
Back
at,
side?
yes, on page
the
910 of the record.
I saw the picture, thank you.
Isn't there also a front awning that you're seeking protection for?
I'm sorry, say again?
Aren't you also seeking protection for a front awning?
We are focusing on the terrace with the glass retractable ceiling on the backside.
The rear.
Yes,
back side.
correct.
Okay.
Primarily, we want to focus on the fact that the trial court should have held that my client is entitled to reimbursement of its reasonable professional fees incurred as a result of the license that was.
So what happened? You were awarded fees until the day of the hearing, right?
What happened, Your Honor, is there was one invoice that was submitted as a matter of course in opposition to the original order to show cause, and the trial court said, well, that's the only one in evidence, and I'm not awarding anything else, despite the fact that the
Well,
trial
you had
court-
an ongoing hearing, didn't you?
Correct. Yes, there were multiple appearances before the trial court and an evidentiary hearing. There was no
So
secret.
did you offer evidence of other legal fees or professional fees incurred?
The witnesses that testified at the trial discussed their professional fees that they had incurred, but we did not put in other legal fees or invoices. And on that score, I think I would direct the court to its recent decision in the 1643.
So why didn't you put in evidence of more recent costs?
Well, for one, Your Honor, we didn't think that it was reasonably disputed at the time of the hearing. And two, we would not be able to put in evidence of all of our fees because
How are you expecting these fees to be paid if not via court order?
well, what we were looking for was the predicate order, which is to follow this court's decision in Pan Asia that says a compulsory licensor is entitled to reasonable professional fees, and if there's a dispute over reasonableness, that could be brought in the ordinary course through a fee petition or a fee affidavit. Sometimes these are severed off for a special referee. That would have been fine. We just wanted the predicate
But you're now
order.
in court having a hearing, and one of the issues for the hearing is fees, is it not?
I think, again, I would direct the court to its recent decision in the 1643 First LLC case, where there was a similar issue. No evidence of fees from the compulsory licensor were submitted, and this court said, nevertheless, even though it's the same trial court justice, that it was going to reverse and remand to order, and I could quote this here, the court to grant respondents reasonable professional fees and attorney's fees. So what we're looking for is step one. The court went to step two, which is the amount. How much are we going to award? There are fees not only leading up to the hearing, but I think I would point the court to Newgarden.
You're at this hearing to decide fees, so you have an invoice from something that happened in the past. You didn't see fit at this hearing to say, Judge, this one invoice is not our only legal fee. There are other legal fees that you should be considering, or there are other professional fees that you should be considering.
That was brought up in argument. It wasn't brought up through an evidence-based approach. I do agree with the court on that front.
So why wasn't it brought up on an evidence-based approach?
Well, like I said, we didn't believe it was in dispute leading up to the hearing, and because we would not be able to capture all of the fees they were asking for because we were incurring them in real time.
So you thought that the respondents were just going to pay these bills?
What we thought was we would get an order that follows Pan Asia that says we're entitled to reasonable professional fees, and if there was a fight between me and my friend on the other side about reasonableness, then we can bring that to the court in some sort of subsequent hearing or petition.
I don't know, every time you're gonna ask for money, you have gotta expect that there's gonna be a fight.
I do agree with that,
This is litigation, not for the faint of heart.
and I agree with that, and that's why these are offered seven
Unless
off.
you're giving them money, that's a different story.
I don't think we can give them money.
Okay, right.
But that would be severed off in many cases in these RPAPL 881s for
So
some sort of special referee.
Is that the only issue before us, the professional fees? Isn't the license fee also in question?
It is. On that, we will rest on our submission. I wanted to focus my energy today on the professional fees, but then also protecting the terrace. And on that score, Your Honor, the building code was not the end-all, be-all. The trial court says, well, the building code didn't require the developer to protect it, but that's not the right standard.
So if you recall at the beginning of your of this particular oral argument, you were asked the status of the building that's being erected at this point in time.
Correct.
So is the issue of the the protection of the retractable roof still alive and well, or is it moot?
That is still a live issue. It is my understanding that nothing bad has happened as of yet, but it is still a live issue. Yes.
Okay, thank you.
Thank you.
Good afternoon, Your Honors. May it please the Court. Chry Cooperman, counsel for respondents. I would like to make just a few brief points on the two issues.
Counsel, before you say anything, is this issue with respect to the retractable roof still an open question, or is all the exterior work done and the issue resolved?
So one of the issues in this case is the retractable roof over the front terrace. And with all due respect to counsel for appellant, it's the front terrace that was litigated, and we think improperly litigated and tried at the hearing. The front terrace, both sides.
That brought in the 60-foot
That's correct, Your
issue,
Honor.
because why would you talk about the back? The back
Absolutely
is
right.
within the 60 feet, right?
Correct. The rear.
It's on the other side of the construction.
Correct. The rear terrace is absolutely protected. It's fully
Right.
protected by the plans, DOB approved.
That was our
engineer
understanding,
approved.
correct.
So that's in fact the issue that was addressed at the hearing. There's a terrace known as the front terrace and referred to it by both sides as the front terrace that it is agreed is far from 20 feet away from the construction site.
Is it facing the construction site?
No, it is not facing the construction site, and as Justice Bluth correctly concluded in her decision, she said it is the side, quote, not the side facing the construction site. It is on the other side of the building. Now, section 3309.
Let me ask you this. The statute, if you look at the regulations, you're not required to do that. But if we were to accept your friend's argument, will we be changing the building code if we were to agree with your friend and say you should put protective, scaffolding for the front? Would that be changed? Would that be outside of the regulations and sort of new horizons in a sense?
I think I would respond to this in two ways. So first, I would say that we have not identified, and counsel for appellant has not identified, a single case in which this court, or as far as we can tell, any court, has ordered protections of this kind beyond 20 feet. So I do believe that it would be the first time that we will have seen that from this court. Second, what we routinely see from decisions from this court, from lower courts, and in the other appellate divisions, is protections that track the building code. And what is written into section 330910 and 330913 of the building code is an opportunity for owners who need to protect beyond 20 feet to go to the DOB commissioner, the commissioner of the Department of Buildings, when there is a quote-unquote unique hazard, and ask that it be protected. And in this case, what occurred? It was not, they didn't even ask. I
Are you
apologize,
aware
Your
of
Honor.
any case law or regulation that requires protections for what's the word? the front terrace, I can't think of the word. In front, facing away from the actual construction?
The only provision of law that we are aware of is section 330910 and 330913. That's protection of roofs and protection of adjoining spaces, which allow for the Department of Buildings Commissioner to issue an order for protection more than 20 feet away from the construction site, only in situations of unique
parsing the
hazard.
word adjoining spaces?
Adjoining spaces. Now, we think here it's not a roof or an adjoining space, but in any event, that's the only provision of law that there is, other than in 880.
Before your time is up, I would like you to address the fee issue.
Oh, yes, Your Honor. So this court Justice Bluth made a determination that it was reasonable in this context, given the facts, to award approximately $20,000 of legal fees. The court made clear that all of the documents in the record, there were 52 documents that were noted on the first page of the court's decision, were considered. Now, there are, as we can tell, 3 scenarios in which a court would order less than the total fees incurred. We think all 3 of those apply here. One of them is fees unreasonably incurred. Another is fees where there is prejudice because of litigation errors, and the litigation errors in this case are clear. We note them in our brief. And also, importantly, as Your Honors were discussing with counsel for appellant, fees not established by evidence after an opportunity to introduce them. Now, there are lines of cases not in the RPAPL 881 context.
Your adversary says that, look, they had a right to get fees even post this hearing that were actually incurred. And he points to Panasia, that this is the procedure, that even though the fees are not brought up at this hearing, post-hearing, they can still claim the fees.
It was determined specifically in Panasia, in fact, that engineering fees for the future, while they can be ordered if a court determines that it's reasonable under the facts. First of all, there are no facts that established any of that here, 1. And 2, the court said in Panasia...
We're not really talking about future fees here. We're talking about fees that at the time of the hearing were actually incurred or were being incurred as the hearing went on. Am I correct?
So that is the position of counsel for appellant. However, what the facts show and what the court determined was that there was no information submitted. There was no evidence introduced at the hearing at all with respect to fees. Now, it was crystal clear at the outset of the hearing. It was ordered by the court and made very clear in an interim order at least a week and a half before the hearing occurred as to what the scope of the hearing would involve. What the court said was that it was going to try all issues with respect to, the all issues is not in quotes, but the following is in quotes, terms of access, as well as, quote, financial issues, all of the financial issues, end quote, would be determined at the hearing. It was very clear. The court also made it clear at the very outset of the hearing that anyone who had an issue that wanted to be raised, they would all be determined today. In fact, they asked me at the beginning of the hearing, what do you want me to decide? And I told the court what we wanted the court to decide. There were certain issues, specifically with respect to physical protections, that were agreed to at the outset of the hearing. So the physical protections other than the front terrace were taken off the table. I said everything else, my response was the terrace issue was to be decided, license fees, professional fees. Now, the court also asked counsel.
Thank you. We got it. Thank you.
Thank you, Your Honors.
First, I will apologize. My friend on the other side is right. I flipped the terraces, but we are still seeking...
Oh, that's a big deal.
That is, but we are still nevertheless seeking that protection for this reason. What we're saying is the court analyzed only the building code.
Yeah, but you know, I hear what you're saying, and if I were to agree with you, I mean, the ramifications would be incredible, right? Because then going forward, every single project that has the RPAPL 885 or 881 component to it would be now, it's no longer following what the building code sets out, but following what we say has to go out, right? Because basically you're saying, we want it, we need it, therefore, and if I agree with you, okay, you got it. Every single project going forward is going to have this case to point to, saying, or in your case, individuals or entities that are in your position are going to say, hey, look at the first department. They said, you know what, we asked, we get it. Doesn't matter what the building code says.
Well, I think that you're going to have to prove that up if you are a compulsory licensor, but I think I would refer Your Honor to...
If the argument would be there.
The argument would be there.
The trial courts will have to follow what we say.
I can't disagree with that, but I would refer you to the New Garden case, where The question here is there authority for a case where protections were ordered that were in excess of the building code? In the new guard,
The protection that you're asking for on the surface seems to be counterintuitive. The construction's going on in the backyard, and you want protection on the other side of your building facing a different street.
we do because we had a witness below that.
And 18 stories have been built, I take it, with that incident to this. And how many stories is the building going to be?
I believe there are 25 that are anticipated, so it's still going vertical.
Sorry, 25 more or
No,
all
total.
told?
Total.
The 7 stories.
So I think in the
Also, can you go to the Department of Buildings and request extra protection?
we could. I don't think that's a precondition to what the court could have awarded below. I don't see that anywhere in
It
881.
may not be a precondition, but it would be a little bit easier in a sense for us to review because then, you know, as we know, agencies have discretion in terms of how they operate and apply their regulations so that if you, as my colleague would say, you go to the building department, you ask for extra protection, they deny your extra protection request, you can Article 78 them, right? You can challenge that saying that that was an abuse of discretion or irrational decision. So there's a record here for us now to give you what we want, to give you perhaps what you want, and at the same time protecting the overall integrity of how this process works, rather than you coming directly to us and say, you got to tell them that they got to do this.
I appreciate the
I
court's
got it.
comments.
Thank you.
Thank you.
Andrea S versus Paul Y. Can you lower the mic, please? Thank you.
Good suggestion.
Thank you.
Should be used to it by now.
We got to hear you well.
Okay, may it
You're up.
please the court, good afternoon. My name is Rhea Friedman, and I'm representing appellant paternal grandmother.
No, counsel, not up, down, closer
Okay,
to
down?
you.
Okay,
Yeah,
Yes,
that's good.
please.
Okay. What we are seeking is, in our reply brief, is something very different from our original brief. As the court knows, unknown to appellant, and she was the only party not in possession of this knowledge, there was an adoption that took place even before the initial brief was perfected. The adoption was made known to me, to my client.
He's not challenging the adoption, right?
No, no.
Okay,
And
so
we
now.
we acknowledge
Right,
that, absolutely.
right. My understanding is now it's a visitation issue, right?
Correct.
Well, shouldn't that go back before family court, before we even hear it in the first instance?
I think what we're seeking is a remand for a best interest hearing. In other words, the threshold issue has already been established, that there are circumstances where equity would seek an appropriate.
I understand what you're saying, but what came to us,
Yes.
how this comes to us is on a dismissal of the petition for custody,
Correct.
which I don't believe, unless I'm mistaken, please correct me if I'm wrong, there was no component of a visitation in there, right? Was
That
there?
is correct.
Right, so that, how do we, what I'm thinking out loud procedurally is how do we remand a petition for custody to have the court below now to address visitation when that wasn't the thrust of the whole application in the first place?
That was dismissed, I understand that. I think
It would require a whole new set of
I
pleadings,
think the
right?
analog is that visitation is a component of custody rights.
Oh.
And given the background of what happened to appellant in this case, I think it's really an interest of justice situation.
Yeah, but you know, the way, call me crazy, but you kind of like to know what the allegations are and try to frame everything and see where it's at. So, you know, the custody petition, you know, I'm not disagreeing with, obviously there's a visitation component, maybe not, because if you got custody, just you got the kids. So that in terms of what other allegations are there to support the visitation claim or application may need to be fleshed out, at least to allow the other side, you know, the benefit of being able to respond.
My client started this case, and there are quite a few months went by where we do not know, the transcripts were not part of the record, but she had significant visitation at the beginning.
Right, correct.
And she was seen favorably by the agency. The clients enjoyed being with her on weekends.
But those visitations were terminated, correct?
Yes, and I'll get to that. Her rights to visitation were more and more constricted. What happened was the first judge who had this case saw this as a reunification case with my client and said, let's look into kin gap, into basically a subsidized custody. And the agency was all for it. And then they did a 180-degree turn. Allegedly, it was solely her disparaging
The foster parents.
the foster parents that curtailed her visitation.
Also
She did
because
have
of
visitation.
COVID, also unfortunately, COVID wrecked everyone's lives. She said she didn't want the children because there was concerns about health
And
concerns.
the court agreed with that in terms of the traveling.
But in terms of during COVID, she had the option to visit them remotely, and she declined that.
That's correct.
And she did have an option to request reinstatement of visitation down below in the lower court, and she failed to do that as well, correct?
When did she have that?
Throughout the proceeding.
It did not happen.
Well,
Could she
that's the point.
now, is anything precluding her from making an application now for visitation?
I frankly do not think that the family court, after an adoption, would entertain a de novo visitation application. And then she would have to go
Why,
through,
why is that? Because she's a grandmother.
no experience.
Oh, I see. That's why you want the remand, because you
Okay,
don't believe
and
she can
also,
make an
there's a
application.
bifurcated proceeding for visitation. And in the custody, it was conceded that there were extraordinary circumstances, and they could move to a best interest hearing. I think she'd have to start trying to reinvent the wheel. If there were denial of her right to file, then there's been tremendous delay, none of which she was responsible for procedurally. There was no notice to her at the termination disposition where all of this could have been hammered out. The purported custody hearing, and I'll rely on the brief, was not a hearing. When a judge months before says, when the parents' attorneys say, our clients want this grandmother to have custody, and the judge said, well, that ship has sailed, that's not going to happen. And the hearing had the hearsay testimony of a caseworker who hadn't had contact with the grandmother the children for quite a while.
Okay, thank you.
Okay, thank you.
You have rebuttal time. Thank you.
Good afternoon, Your Honors. May it please the Court, Diana Lawless for ACS. We've all discussed already, this is moot.
Well, let me ask you a question. And as my colleagues asked, she's not precluded from making applications before family court for visitation, is she?
Correct, but I would like to make a point where everybody's like, oh, it's so easy, we can just reopen. I represent ACS. We no longer have custody over this child. The children have been adopted. The proceedings now, this family court proceeding that
It's over.
is over. She's trying to reopen something that not
Yeah.
only is it over, she can't reopen it.
And I was making that point because this initially started as a custody position, and now it's morphed into something different, which,
on reply on appeal.
and you can't, that's just, it does
Right.
violence to the procedural aspects of everything.
Well, I mean, I think the biggest problem is that the appellant took over 2 years to perfect this appeal, and the adoptions happened during that time, and the proceeding changed dramatically then. And
That's why I asked if she's not, from what I read here, she's not challenging the adoption at all.
she said she's not challenging the adoption. So, and also, it's her, I know she's like, oh, she reverted to visitation in her reply brief. The cases that say that the adoption prevents her from having standing for custody, it's the same thing for visitation. It's because the status of the parties have changed, right? It's because before it was the parents, and her rights were compared to the parents' rights. Now there's been adoptions, the children were freed for adoptions, the children have been adopted. ACS is not a party to that anymore. It's now these parents who are the legal parents of the children, and any claim she has for visitation.
What would happen if we were to agree with your friend and remand this for a hearing of visitation? How would that look like?
I don't know the current parents of the children are not parties to her
Oh,
prior.
that's right.
Right. They're not parties to this ACS. That's why I'm here.
That's right.
So that's why custody has changed so dramatically.
couldn't do it,
That's why the cases are very clear, because ACS was the legal, right, had the legal custody of the children before the
You're not
adoption.
the right party.
We're not the right party anymore.
Got it.
And the legal standards, as we go into my brief about what makes you have standing and why you have, who has custodial rights and how they're weighed differently in law for who's comparing to who.
So, counsel, when I first was reading the briefs, my understanding was that judicial economy was part of the argument being made by your adversary. What you're saying is that judicial economy really would not be served, because if you don't have a party, you don't have a party.
Right. We don't have the party at this point, and just have to. And the legal standards are different. It's not it's not the best interest standards that applied below with respect to when the child was in ACS custody versus the foster parents. Now it is the legal parents of the children by adoption and what visitation rights a grandparent would have for that. It's a whole different ballgame. I mean, they could consent, right? They could consent to visitation. That's something that they're allowed to do as a parent, right? People are allowed to do that for family members. So it doesn't have to be a court proceeding. I don't know about what their positions are in any of this.
Got it.
So it's that the ship has just sailed, and it's because this is a 2021 order.
Thank you.
All right, thank you, Your Honors.
May I?
Yeah, sure.
Okay. I have no idea how my client would serve the adoptive parents without some
Well, I mean, she
knowledge-
makes it, unless I heard wrong, I mean, ACS is not a proper party to that visitation situation. It's the new
with a-
parents.
With a court order, ACS could identify the adoptive.
Well, that's for you to make the application before family court.
Okay.
I don't think this court is inclined to tell courts below what to do in terms of procedural matters.
There are
I
many
mean, I don't think
cases
you're
where
going to find any precedent which says that in this proceeding, we're going to order ACS to provide you with information about the adoptive.
there are many cases where where grandparents seek visitation after adoptions. That's not a novel situation, obviously.
Right, but not in the way you want it to be done here, right? I mean, I don't disagree that you're right, that grandparents can seek visitation, but not in this context. You're asking for a very unique.
It also did not take 2 years to perfect. In fact, I have no idea why ACS and the lawyer for the children were not aware of an adoption.
You know,
that took
for me,
place.
that's not something of my concern. My concern is how you're asking for us to remand it for a visitation hearing. Remand this petition, the custody position for visitation.
If that were done, could not the family court fashion appropriate service?
I don't know.
and look into that? So I am asking for something to counteract what happened to my client in this case.
Okay.
Thank you.
Thank you. Jewish Press versus New York City Department of Finance. Justice Friedman is recused from the matter. Don't go far. You're up, counsel.
Okay, good afternoon, Your Honors. If it pleases the court, Joseph Aaron for the petitioner appellant, the Jewish Press. So, because of procedurally what went on, this is pretty straightforward, I think, for this court.
Oh, I have so many cases to show you that
They all start that
straightforward.
way,
They all
huh?
start out by saying it's straightforward.
Okay,
And those
I
are the
hope- I
ones
hope
that
I'm
are,
right.
those are the ones that can provide us with the thorniest situations.
Okay, well.
You already gave us a warning.
Uh-oh. I'll try to recorrect.
Thank you.
We filed a petition for documents subject to FOIL. The Department of Finance appeared but ultimately didn't oppose. And the judge below, notwithstanding, denied our petition. Now, under FOIL, there's a presumption of access. Practically speaking, what that means is once we file a petition and say, hey, we didn't get the documents, the burden is on Department of Finance. And I don't think that's a controversial point. So because they failed to oppose and put forward any evidence, there's no evidence in the record because they didn't oppose, they can't possibly win. Now, that's what I thought was a simple part. To go into more detail,
Isn't it a situation here, unless I could be wrong, the respondent here is relying on some letter later on that says that they gave you all they had, and now there's a situation here, there was never an answer to your petition, and the Supreme Court kind of just went ahead and resolved your petition without an answer and without even having a full record in front of it in terms of what the respondent was saying to respond to your FOIL request. Isn't that what's missing in the record here?
I don't think that's an accurate representation of the facts at all because it was based on an exemption. They said the records were exempt based on privacy. And therefore, instead of giving the records, they gave a spreadsheet that summarized some of the data in the records. Now,
I want to, before you go any further, counsel, did you include in the record the note from February 8th, 2023 on open records, which explained the Department of I have here F, DOF.
Department of Finance.
I thought so, but I wasn't positive. Couldn't locate the requested application and the supporting documents. Aren't we missing a document that is kind of critical to our review?
So I don't think we're missing any document at all. What the court has in front of it is a FOIL request, literally 2 years of extensions from Department of Finance when the law provides for 20 days, a determination that's in the record, an appeal of the determination, and an appeal determination. So, in fact...
So what you're saying is that there is no evidence in this record that any files are missing?
Your Honor, that's
despite
correct.
their
But
representation.
let me say two things. First of all, under CPLR 7D804E, I believe, it's the city that has the obligation to put in the full administrative record, not the petitioner.
But what I'm asking you
statutory.
is, according to the Public Officers Law, when an agency can't locate a document that's requested under FOIL, they're supposed to certify that they don't have it. And supposedly, this note on open records explained that they didn't have it.
So two things. They never certified that they didn't, and even if they did, it wouldn't make a difference because under the CPLR, they would have had to put evidence in at the proceeding. It's not for truth of a matter asserted.
Right, but that's what an answer would do for you, right? An
Correct.
answer would
Correct.
have...
They should put in an affidavit under the penalties of perjury, which is a certification under the FOIL.
I think we're saying the same thing, we're just going
Absolutely.
around in circles. It's a different way of saying it.
Absolutely.
You say affidavit, I say answer,
Yes.
you say potato, I say potato.
Yes,
Same
I
thing
think
going
we
back
see
and
it. I
forth.
think we see it
Got
the
it.
same way. But the way the FOIL is worked, and especially, I just want to underscore this exemption, privacy more than any other. Privacy statutorily doesn't allow for blanket withholding. You have to redact sensitive information unless they could show, this is sensitive, this isn't, and that's done by affidavits
So we know that
with
part.
facts.
We know that part. But with respect to the answer that wasn't filed, are you saying that this procedure, this appeal, this case should be remanded so that they do file an answer?
No, so I actually don't think procedurally it should be remanded and allowed to. The CPLR, and they cite it, says that if they don't put an answer, the trial court judge has two options. They could either order them to put an answer or they could render judgment. They render judgment. I'm not representing Department of Finance, obviously, but I think procedural mechanism would be, after this court says what it says, for them to move to vacate.
So let me say this. Assuming I agree with you, saying that we can tell them to turn it over, and as my colleague points out, I agree with you, and I say turn over the documents. Their response is to that letter that it's not in the record saying we gave everything we have. We don't have anything else.
So I'll say two things. To my knowledge, they never. What got conflated from the trial judge, by the way, was the whole administrative appeal and petition was only about the applications. The FOIL request was for four things.
Didn't the court deny the petition before the Department of Finance put in an answer?
They never put in an answer.
No.
You got to follow the question.
Follow the question. Didn't the court deny the petition before the Department of Finance filed their answer?
Yes.
Okay, thank you. You have rebuttal time.
Good afternoon, Your Honors. May it please the court, Diana Lawless. for the
Welcome back.
Welcome back. And I really do want to start by apologizing to the court for all the chaos that has been caused by the fact of the admitted law office failure of my office and what
Falling on the sword.
What?
Falling on the sword, as they say, right?
It has caused a lot of problems, but
Okay.
we did ask to put in an answer right in the court on the record. Just granted, the denied the petition, and I really do want to make clear about the record why we're arguing it this way, as Your Honor pointed out, Justice Gonzalez.
You're talking too fast.
Oh, I'm sorry. I'm getting a little stressed about this one. I just spent a lot of time on this. So, to correct the record, he put in the record his request, which was for all the applications. The letter, Your Honor, Justice Gonzalez, that you're referring to, it's the first determination. The open records document is the first determination. He didn't put that in. And then he put in the appeal, which just says, oh, I want everything, and I complain about there's no, I oppose the redactions. The response is the record access off. The only thing is the final administration. The appeals decision is here, not the initial decision, which said the initial decision, which I can represent to Your Honors, is that we don't have the ability to determine which applications meet the time period in the request, and we can't locate the applications supporting documents. And then we said that we provided the information we maintain for this tax exemption for all households that hold it. That's what we gave him. We gave him a spreadsheet. All his arguments on appeal are, well, no, you just put the information in the spreadsheet and I'm entitled to the papers. But that's actually not the response we gave him. So the Record Access Appeals Officer, which is the appeals determination, that's what's in the record, and you can see his 2-sentence appeal says, well, what about the applications? I want the applications. And
Counsel, what's the remedy?
the remedy, I think the best remedy is a remand for us to file an answer. And I will point to what are the cases I cited on pages 28 and 29 of our brief about the CPLR, about the Article 78, and when relief should be granted to the petitioner, which is what he asked for. It should only be granted without an answer when the facts are sufficiently presented in the papers of the parties that it's clear that no dispute as to the facts exists and no prejudice will result from the failure to require an answer. We believe here, based on his legal arguments, the legal arguments he is asking you to accept, and as Justice Oing said at the end, oh, well, isn't there going to be a problem if we give you what you want and they come back and say that we actually never had them available to you? That is our actual problem, because this record, as currently constituted without the participation of the Department of Finance.
So, counsel, with respect to the denial of the petition before you answered, okay. No.
The denial.
Am I right? Am I right?
Yes, the denial, right. The denial before we answered. Yes.
Did you engage in any dilatory tactics that would have perhaps persuaded the court to just go forward without your answer?
I don't know. All I know is
I'm asking you, is there anything in writing or is there anything in the record?
There's nothing except for the letter we put in saying, please give us an extension. We just found out from counsel that this happened and we had forwarded it. We had forwarded to Department of Finance, and the person we forwarded to was no longer there and no longer had an out of office. So we didn't know that we assumed they would handle the case and they did not. And we put in.
So you're saying that there was a change in personnel and that accounts for the reason why
of the dilatory conduct between my office, the Corporation Counsel's office, and between the Corporation Counsel's office and the Department of Finance, because the Corporation Counsel's office does quite often have the agencies litigate the FOIL litigations. And that's the deputy chief of the division, and he wrote immediately, we're going to assign somebody to it, we just need some extra time. And the court took that and issued a decision, and then right with it denied our request. So it wasn't us trying to pull the wool over anybody's eyes. We just really, really messed up on personnel issues here.
Thank you.
So, thank you, Your Honor.
If I could just make 3 very quick points. So one of the big points here, and I hear it's the biggest concern of Your Honors, is what if the documents don't exist? She never said that, and they never said that. They can see they exist. She's saying it's not clear the 5-year period. My response to that is, that makes no sense.
Well, if they flesh out the record, if we listen to if we agree with what she's arguing or putting forth before us, a remand would allow you now to have a full record, and at that point make a determination whether or not there was contumacious behavior, dilatory activity going on. All that will be at your fingertips, which will give you a better, I guess, argument if it doesn't turn out the way you want it to turn out. Because right now you have a scant record. You don't have a complete record. You got half a record, let's just say.
But I made my case. They failed to meet their burden. So my contention is the court.
Of course, you're going to make your case.
Has to grant me the relief.
It's easier to make your case because you put everything in front, but they haven't put anything in, right?
So she should have to vacate, though, because what she cites to her paper, she doesn't cite a single case that this court has the legal authority to remand now, as opposed to her vacating. Meaning, procedurally, petitioner should be granted its relief in the entirety, and then she should move to vacate and show, like she keeps on saying, we had a reasonable law office failure. That's great. So the CPLR has a mechanism to demonstrate that. She doesn't have a motion in front of this court or any court to vacate.
Wait a second. You're appealing Supreme Court's denial of your petition. If we affirm, you can move are you going to?
No. I'm saying it should be reversed. That's my argument.
Right. Well, let's say if I don't,
remand is not something that's available for this court, because the question in front of this court is whether or not the final determination of DOF, which is in the record and in the petition, was made in error in light of the FOIL statute. That's the question. Meaning the trial court said that the final determination was good. We're asking this court to say no. The determination by DOF, which is in the record.
Even though we don't have the full record in front of us.
But that's not full. That determination that she's saying was missing was superseded.
The letter.
But that doesn't make a difference. The Article 78 is to challenge the final agency determination. The final agency determination is in the petition. It's in the record in front of Your Honor. She's saying 2 years earlier they made another determination. That was totally superseded. The final agency determination is right here now
Saying that when
on the record on appeal.
When we review a decision, we don't look at the decisions that preceded it when they're all piggybacked one on the other? This
Yes,
is an appeal
and there's case law from this department, specifically in the FOIL context, that administrative determination supersedes, and that an agency, I don't know if the words waive or abandons exemptions they waived in the initial one, 100%. That if an agency raised one exemption, let's say privacy, and then somebody appeals and they say, oh, now interference with law enforcement, I'm just making it up. This court has said that the prior exemption is deemed abandoned if it's not in the final administrative determination.
Okay.
So that is what this court has previously held. It wasn't an issue in the papers.
Thank you.
Thank you, Your Honors.
Santana versus Patel. Just 1 second. Welcome back. Okay, counsel, you're up.
Good afternoon, Your Honors. May it please the court, Louis Bottolato for Ramona Santana, the plaintiff appellant. Your Honor, because the express purpose of the National Vaccine Injury, the National Childhood Vaccine Injury Act is to ensure the continued supply of vaccine and the willingness of doctors to administer a vaccine.
I know the way I understand your argument is that you're suing or litigating in terms of the administration of the vaccine. They're using this air device or some sort of what kind of pressurized injection, and your claim is that the pharmacist was negligent in that regard, and it had nothing to do with the vaccine. That's incorporated or covered by the federal law.
Correct. The Federal Circuit Court of Appeals on 3 occasions, once in dicta and 2 in holdings, has indicated that the NCVIA does not apply and does not preempt, quote, where, quote, the vaccine, unless, quote, the vaccine must be a substantial factor in bringing about the harm, close quote. That's from the Shy Face versus Secretary of Health and Human Services, which is cited in my brief, a 1999 Federal Circuit case. In a case called All, the court indicated, quote, and this is citing back to its earlier decision in Amendola. This is a 2006 decision citing a 1993 decision.
But doesn't 42 USC section 300, you know the site, it says right here in my notes, a vaccine-related injury or death associated with the administration of a vaccine.
And that's been interpreted by the Federal Circuit to only involve cases. Here's a quote.
What about Hallowell, 2008?
Okay,
18?
Sure, that's a lower court case. That's a unpublished Western District of Washington case that cannot overturn the higher Federal Circuit cases that hold directly to the contrary. Additionally, the rationale of that case tries to distinguish between injuries that are tabled injuries and injuries that are not tabled injuries, saying that if it's a tabled injury, there's nothing that can be done about it. It has to be covered by the statute. But that's not at all what the federal regulations say. Federal Regulation 42 CFR 100.3 C10 sub Roman numeral 4 states that the NCVIA does not apply where, rather than the effects of the vaccine, another, quote, condition or abnormality is present that would explain the patient's symptoms, close quote. This is a situation where the injury has nothing to do with the efficacy of the vaccine.
I thought about, go ahead. Do you want to
I
ask your
was
question?
just, let's say we affirm. Wouldn't you still have an opportunity now to bring a claim based on the National Vaccine Injury Compensation Program?
Absolutely, you'd just be delaying the inevitable by approximately a year. What would happen if you affirm is, we would then have to go and jump through the hoops, filing a petition.
What's wrong with that? I mean, if that's the process that's laid out, what's wrong with that? It's
not
like an
the-
administrative
It's the process
exhaustion.
that laid out.
Yeah, let me
I'm sorry,
finish my.
I apologize, Your Honor.
I know you're excited, but you gotta let me finish
I
my
do
sentence.
apologize.
So it's almost as if exhausting your administrative remedies, right? I mean, that's what that's Congress did that, right? I mean,
Understood, but Congress specified that it has to be a, quote, vaccine-related injury. And the Federal Circuit, the court that
Counsel, how
determines
is
these
it
issues.
not a vaccine-related injury? I mean, I hear you. I hear you when you say this is solely dealing with the administration of the vaccine, but it's not an empty needle that's going into the shoulder. It's an empty needle with vaccine in it, which then causes a reaction that results in injury. So aren't the two married together?
According to the Federal Circuit Court of Appeals, absolutely not. I'm going to quote you from the All case, AULL. This is a 2006 Federal Circuit case. Quote, the court in Amendola thus had in view a distinction based on whether the negligence was related to the vaccine's effects. This makes sense in light of the purpose of the NCVIA. Permitting a civil action against a doctor for dropping a child during the vaccination visit to proceed simultaneously in no way jeopardizes the continued supply of the vaccine.
Dropping a child is not the same.
Understood. If you let me finish the quote, it'll get exactly.
But I read that quote.
She read that. That's why she said.
If you stick the arm with a dirty needle, it still is.
Well, that's why she's jumping up and down. She read the quote. Let me point one thing out, and this. You know what? I'll get her on rebuttal. Thank you.
Good afternoon. May it please the court. My name is Lauren Donnelly, and I represent the defendants' respondents in this case.
So you rely, do you not, on the fact that the shoulder injury related to vaccine administration is a provision which is part of the table of vaccine-related injuries?
Yes.
The injury table, but it was added in 2017, right?
I'm sorry?
SIRVA was added in 2017, right?
I believe so.
And plaintiff was injured in 2015, right?
I think it was still.
My question is, I'll let you speak in a moment, but my question is, if you're relying on SIRVA, doesn't the fact that, what impact does the fact that SIRVA was added after plaintiff's injury have on your case?
It has no impact. Number one, if it was a non-table injury, it still would have to go through the compensation program. The standard of review would be whether it's a substantial factor in causing injury. Where it's a tabled injury, there's a presumption of negligence. So it doesn't change whether the plaintiff has to go through the compensation program before it can obtain a final judgment, and then either accept that judgment or reject it, and then proceed to a civil proceeding in this particular case. So either way, it doesn't make a difference whether SIRVA was added before or after. It's still a vaccine-related injury. And the mere fact that even subsequently it was enacted as a shoulder injury related to the vaccine just meant that it was now a tabled injury. It doesn't mean that it was unrelated to the vaccine administration.
And that simplifies the burden for anybody who's alleging an injury that's vaccine-related, right?
Correct.
As you were pointing out.
Yes. So if it's a table,
You just have to show that that you fall within the guidelines of the table.
yes, and it also has to show that the injury manifested within a certain period of time, which plaintiff felt the effects of the vaccine administration immediately. She continued her treatment for more than 6 months afterwards. Obviously this flu vaccine is the table injury, and plaintiff did not have any condition or prior injury to her left shoulder, no MRI to her left shoulder prior to this. So they satisfied.
Counsel, to the extent that the benefits are procedural, right?
Yes.
Where a plaintiff is concerned, is there a downside? I don't recall seeing anything in the record, but maybe I missed it, or maybe I didn't see it in the statute. Is there a downside because there's a limitation as to the level of compensation that could be achieved?
There's no limitation because the plaintiff can accept the award in the final judgment if it's awarded anything from the program, or it can reject it. And if it's unsatisfied, say the Federal Court of Claims awarded $10,000 and plaintiff believes that their injury is worth $300,000, plaintiff can reject that award and then proceed with the civil proceeding.
What's your response to counsel's reliance on the Federal Circuit case? He was saying it's spot on, and should compel the result.
All?
Yeah.
Yes, that was. I think there's other cases that are more on to the point on that. I disagree with his interpretation of it, and as it relates to that specific dropping a baby, that's apples and oranges. It's also in dicta. It's a hypothetical, and the court should not be persuaded by that particular argument.
In my mind, I'm reading the statute here, and it could have simply said, when it says a vaccine-related injury or death associated with it says administration of a vaccine. It could have just simply said associated with a vaccine without the word administration at all. I mean, if you want to exclude, or if Congress or the legislature wanted to exclude administration,
yes,
because we know that that's got to be part and parcel.
Right.
They go hand in hand, right? The vaccine
Right.
and administration.
Right.
They could have just left that out, and then you would have been clear at that point
Yes.
that it's administration. You're good to go.
It's the content of the vaccine as opposed to administration, but the administration here is part of the statute. So,
Okay.
Thank you.
Thank you.
Your Honor, in direct answer to your question just now, the reason the word administration is in there has nothing to do with proximate causation. It has to do with the fact that the statute is intended to protect both the vaccine company that makes the vaccine and the doctor that administers the vaccine. But I want to go directly to the case Chry.
So you're saying that there's no benefit to the plaintiff, to a plaintiff who...
There is no benefit from this program to a plaintiff. It's just meant to delay the recovery because, contrary to what my experience with this has been, that, as she said, they'll give you like $10,000, which isn't worth a thing, to a guy who's had 2 surgeries or a lady who's had 2 surgeries as a result of the injury. It just lets them hold on to their money for another year. But that's not the point. The point I'm trying to make here is that in Chry, the court specifically adopted the restatement second of torts. It said, we like what the restatement second of torts said on this subject. And let me quote to you from that, because it is absolutely almost directly on point and in our favor. It said, quote, patient's civil action against pediatrician and pediatrician's employer for pediatrician's alleged negligence in injecting the needle into her buttocks, causing nerve damage to the sciatic nerve and leading to permanent injury to her leg, did not seek damages for a vaccine-related injury, and thus action in state court was not barred by the Vaccine Act. The cause of action was not based on the physical effects of the vaccine. That's the restatement second of torts, which was adopted by the Chry case, the Federal Circuit, the equivalent of you on a federal level, not a lower court just deciding something. A Circuit Court of Appeals, a panel of judges, not once, not twice, but 3 times addressed the question. Yes, some of them are somewhat distinguishable. One of them was certainly a case where they were talking about it in dicta, where they were talking about it in a hypothetical stance. But Skyface is not a hypothetical. It's a 1999 determination that adopts the restatement second of torts that specifically says that I'm correct here. Because we're not saying the vaccine caused the problem. We're saying that the use of this device in the wrong place tore up the interior of her arm and caused her to have 2 surgeries, that under the facts of this case,
One quick question. But shy face didn't involve an injury listed in the vaccine injury table, am I
The
right?
vaccine injury table didn't even exist
Didn't
at that
exist
point.
then.
But again, as was pointed out quite clearly, it's just a question of burden of proof. It has nothing to do with whether or not the statute applies.
Thank you, counsel. Thank you both. Ream versus Taylor Freeze Capital. Counsel, you're up.
Your Honor, may it please the court, William K. Whitner for Appellant Ravine. This case involves a startup company with an agreement with a financial advisor and two provisions that related to fees that may have been owed or paid to this financial advisor. Those two provisions are really at the heart of this dispute. Those two provisions, one a 2-year tail agreement and one a right of first refusal. Both.
Your challenge is the Supreme Court's denial of your motion. This all deals with the defendant's counterclaims, correct?
That's correct, Your Honor.
So your challenge on the appeal, it's two-pronged. One is with respect to the 2-year tail right, and the other one with respect to the discounted conversion rights, correct?
That's correct, Your Honor.
Right. So why do you think we should overturn the Supreme Court's decision to let that ride, the 2-year tail?
Because it's an unenforceable agreement to agree, Your Honor. It leaves open for negotiation both the price of what the advisor may have been.
Why don't you think that under Cowan that the cause of action survives on this pleading motion?
You said, why did it survive on Cowan?
Why doesn't Cowan supply sufficient authority for the view that the cause of action, the counterclaim, should as a matter of pleading at least, continue?
It does not, Your Honor. That case, Cowan, two things. One, the agreement referred to the investment banking industry as the parameter or the basis of how one could come to fees. That fits with earlier case law that requires an objective standard to come with fees. Our provision has no such common standard that in Cowan the court said that this court routinely adopts this standard to come up with a price term.
So what don't you feel enough of a standard is provided by the fact that the agreement says, together with prevailing customs and practices among financial advisors acting in similar transactions? I mean, there presumably could be established what that practice is.
Your Honor, I don't think it could be established, but I think the bigger part of that is exactly what you said, together with. That means in addition to. So before you get to that custom and practice, you have to deal with the agreement specifically says the factors to be considered, and it says inter alia. So that means there are other factors that it can be considered that is not even enumerated in the provision. But the factors that are enumerated, results obtained and value received, are both subjective factors, like who determines what value is received. And I would put it this way, Your Honor, no third party would be able to take this provision without further discussion, further expression from the parties, which is what the Cobble Hill case says cannot happen, and come up with a price term based on these provisions. The value received to my client, the respondent, is purely subjective, that only they can determine. The results obtained the same way. That's a purely subjective provision that only they can determine. Cowan didn't have any of that.
Okay. Go ahead. Continue, please.
Okay. Thank you. Your Honors, Albert Myers for the defendant, counterclaim plaintiff, and appellate respondent. Taylor Fair Capital Markets, LLC. The two-year
your challenge is two issues, if I recall, right? One is where the court granted the dismissal of the discounted conversion rights as it relates to a breach of contract claim, and then the second one was the declaratory judgment for the financial advisor right of first refusal.
Yes, Your Honor.
Late fee, right?
Yes,
You're
Your Honor.
thinking that the court got it wrong there.
Yes, Your Honor.
Why?
Okay, on the financial advisor right of first refusal, the court did not hold that it was not an unenforceable agreement to agree. It seemed to
Yeah,
suggest
the
that-
court said that the right of first refusal, as I understand, and as the court said, is, you know, the traditional notion is when you have a right of first refusal, you have a third party involved, right?
Right.
And in this case here, the fact that plaintiff went out and did something didn't involve, and in fact, you can, somewhere in the pleadings where there was no third party
Correct.
for you to even have a right of first refusal to go to, right? So why
Right.
is that wrong being dismissed?
Well, because the clause itself did not contemplate or mention any necessity of going to a third party, approaching a third party, negotiating with a third party, or anything. It was just
Doesn't that third party have to exist?
Well, I would, Justice Friedman, I would answer no to that because courts are perfectly willing to perfectly willing to enforce clauses which require you to hire someone.
Well, hold on a second. That, unless I'm in the wrong one, it says, shall be granted an unconditional right of first refusal to act as even exclusive financial advisor. So even though it doesn't say that you have to have another third party, you know, you read that straight up, you have to have another player involved, right? Because, I mean, you know.
Respectfully, I would argue no, Your Honor.
Isn't it the way you're asking us to interpret it is not, it wouldn't be a right of first refusal, it would be a right to act as a financial advisor.
Exactly, Your Honor.
It says right of first refusal as opposed to a straight right.
Right, and New York courts say you can interpret what is something is called is not dispositive. New
You're
York.
saying that in essence, the intent was that you have the right to act as their financial advisor, period.
Yes, as in the Deutsche Bank case and the Moelis case that we cited, which required just simply that you be hired. And I would say, Your Honor, that the words of first refusal, they could refer to, well, we have the right to decline this hiring. We don't have to act and earn if we don't want to. That's why it's a right. So you can refuse to serve.
Well, at the time that you asserted this counterclaim, were you no longer their financial advisor?
Well, that was long past the point where we were their
The contract's
financial-
over and done, right?
Well, yes, but there was, this was in the manner of a tail right. So it lasted until the end of, if I'm not mistaken, 2018, which is 2 years after we were terminated. And I would say just that the first refusal language, that's a nomenclature issue. And we cited numerous cases saying that courts have to get to the substance of it.
And we are looking at the substance of it.
Counsel, us interpreting it your way as just a right to be the financial advisor. The clause, however, is lacking the other hallmarks of that right. So wouldn't it render it then an agreement to agree?
I didn't hear what you said about the
Wouldn't they just
hallmarks.
render it? It's missing some of the other hallmarks, right? That are usually included.
Well, I would argue no, Your Honor. The Daiwa case that Justice Cohen had decided in the trial court below said that this is not an agreement to agree. In fact, it's the same language. There's no meaningful difference between similar transactions in the investment banking industry and Daiwa. And I'm sorry, there's no meaningful distinction between what Daiwa held was acceptable, similar transactions in the investment banking industry, and what our clause held, which is you have to negotiate the compensation based on, quote, established customs and practices for financial advisors.
But the clause doesn't include what Chry's duties would be, does it?
No, it doesn't, Your Honor. But keep in mind that Taylor Frere was their financial advisor for 2 years, and it's precisely the same types of transactions that Taylor Frere helped them achieve their original $35 million. And then they went off and did it themselves, do-it-yourself kind of thing, and raised another 25. And we argue that we should have been and must have been offered the right to serve as the financial advisor there. Thank you, Your Honor.
Your Honors, in response, I would just sort of respond to the last point in terms of the words say what they say, and it's pretty
Yeah,
clear. It's
his
official.
argument is that this right of first refusal, sorry, Jesus, I thought I turned this off. Don't yell at anybody, it's me. The way he interpreted the right of first, it's a right that he has to remain as your financial advisor. How does that, to me, that's kind of like, how does that play in when you have a termination clause elsewhere that says that on notice you can terminate your relationship? Because if they have the right to remain as your financial advisor, then you won't be able to terminate them, right? I mean, if that's the way I'm thinking it.
Well, that's right, Your Honor. It doesn't fit with the party's practice. It doesn't fit with the agreement, and it doesn't even fit practically, because what my colleague is essentially saying is my client had the obligation to hire someone for something it didn't need and then agreed to negotiate terms for a service it never used.
So
essentially where we would be left.
So it would definitely need a third party. There would definitely need to be a third party for this to kick in, and there wasn't.
The only way it would take place is to be a third party, and that's the case. Now you have a third party who acted in that role that a court can then say, this is what you hired someone for. They had the right to do that. This is what their compensation is. Here, you don't have anyone.
So I'm looking at the timeline. Let's see. There's information that comes to light that $45 million in new capital was achieved between July 2017 and October 2020, right?
Yes, Your Honor.
Okay. And then right after that, there's a letter that goes out to Taylor. How do you say F-R-E-R?
Frere.
Frere, yeah. Thank you. To Taylor Frere, that says, you've breached your fiduciary duties and now we're prepared to sue. Is there a link between that information and that letter?
No, Your Honor. The letter had to do with the parties trying to figure out what, if anything, might have been owed to them for my client to clean up a cap table.
So then going backwards, there was a letter in July 14th of 2017 where the chief financial officer of Ravim?
Yes, Your Honor.
Acknowledged that there was an obligation to issue shares, as in 851,000 extra, plus shares of preferred stock. Did that happen, or was that letter of 2020 linked to the 2017 acknowledgement by Mr. Rice?
They're completely separate issues, and what that stock, or what he's owed, is still subject of this ongoing dispute. So the dispute is not your resolution today is not dispositive of this case. So that breach is still an ongoing issue in terms of what he might be owed. As to these two provisions, is separate. Yes, Your Honor.
Thank you.
Thank you.
Yes, yeah, you have 3 minutes, correct. You have 3 minutes on
Okay,
your.
thank you. So
go ahead, Jeff.
So to go back to the two-year tail, what is the custom and practice that we're going to turn to when you try to figure out what you're now entitled to?
Well, it's so let me answer your question, Justice Friedman, by going back to Cowan. Cowan said investment banking industry practice is acceptable. And
Cowan was on a summary judgment motion, right? It wasn't on a plea.
Yes, exactly. And in a prior motion, which I believe Your Honor denied, that issue came up, and Your Honor denied the motion to dismiss, as I think this panel should affirm here. But I would just say that if investment banking industry practice is sufficiently definite, then so by all rights and logic is the reference in our tail right, which is to prevailing customs and practices among financial advisors in similar transactions. Now you might say, well, Mr. Whitner said, well, investment industry banking is fixed and invariable, whereas our clause is amorphous and vague. I respectfully disagree. Our clause is even more specific. The focus is not on an entire industry.
The results obtained in value derived clause, how is that to be figured out?
Well, Your Honor, when you say the value and the results, it's not like we're talking about, well, what's your satisfaction? Are you satisfied? Yeah, and boy, this was a great deal. No, we're talking dollar amounts.
How is this to be computed?
Well, the value, I think both arguably should be computed by how much did you raise and what would be an appropriate compensation to pay you based on how much you raised. And in the industry, we may find, and we may also look to the past practice of these same two parties, well, was there a percentage? Or was there a fixed rate and a hybrid? Maybe fixed rate and a percentage.
Sounds like you're saying it's quantifiable.
Yes, Your
It's
Honor.
not illusory.
Yeah, absolutely.
And of course, you'd point to the fact that it says appropriate supplemental compensation, which seems to contemplate that there would be some payment.
Yes, as the trial court found, this was a present agreement that there shall be some compensation, which Ravim then proceeded to deny for many years. If I have one more second, I would just say Mr. Whitner referred to the presence of this phrase inter alia as if it's a talisman, really, that would void an otherwise acceptable clause. We say inter alia means among others. And in this context, it means it's got to, so there's two factors, inter alia. It's got to include those two, but beyond that, you could also consider others. It means include but not be limited to. There's absolutely no case that says that the mere phrase inter alia dooms your otherwise perfectly acceptable clause.
Thank you, counsel.
Thank you so much.
Both. People versus Amato Zubidi.
Good afternoon, and may it please the court. Barbara Zolot for Appellant Amato Zubidi. Your Honors, the police unlawfully stopped Mr. Zubidi's car on May 18th, 2019.
Why is it that car, that van, and the license plate were already, there was a bolo out on it, correct?
Correct.
So putting aside who's driving that car, didn't the police have reasonable suspicion to stop that vehicle, having the bolo out there?
No, Your Honor, because what reasonable suspicion requires is reasonable suspicion that the drivers or occupants were engaged in some criminal.
So you're arguing it doesn't matter if the car is exactly the car that's in the bolo, that the police have to ignore that and let it just not even stop it?
The passage of time is really the critical element.
Well, here, the passage of time, this case is different in that there are two incidents, right? One regarding a shooting, and shots fired, I should say. And from that incident, we have an eyewitness that definitively gives the license plate and the car. So the make, model, the license plate, and the car, that's not in question.
Correct.
That happened weeks prior.
Correct.
The day before, same vehicles involved in attempting to run over a traffic officer. It's the day before.
Let me address the ticket agent encounter and why that neither independently provides nor contributes to reasonable suspicion. Really, three reasons. One is, first, it was 24 hours before, and even that is too long of a gap. And I would refer you to Cayman's, the treatise for search and seizure, which did a survey of cases where it's
No, stick to the law. We have enough problem with the case law. Why don't you just give us cases? When you talk about treaties.
Okay, people against, that's fine.
I'm sorry, but I got enough problem with the cases before I have to read
Well, he surveyed all the cases.
Well, that's fine. I survey a lot of things too.
Drew the line at 45 minutes, just say that. But people against Taylor, it was 2.5 hours. We cite that in our brief, and that was too long a gap to just act on the description of the car alone. What the police...
the description of the car, they had a license plate. Someone took a picture of that car with the license plate.
Agree, it's the car, but the point is that when there's this gap of time, and even 24 hours comes within that gap
I understand
of
the
time,
gap of time. I understand when you have a gap of time that the vehicle that you see may not be the right vehicle. I mean, you think it's the right vehicle, but when you have the identification of the license plate, unless they're putting that license plate on another vehicle, that license plate, they're running those plates. It is the car in the bolo.
No question, but what they do not What they don't have is individualized suspicion that the person driving the
I'm not talking about the person there. I'm talking about stopping that car. Did they have reasonable suspicion to stop that car?
But that's not what you can't. There's no really such thing as reasonable suspicion
Okay.
to stop a car.
Well,
what
we're talking
can
about here is
show
a Fourth Amendment right, right? And the Fourth Amendment right, the car doesn't have Fourth Amendment rights.
Essentially, exactly. And I mean, as the standard is stated.
So your argument is that because they didn't know who the driver was, it's his rights that were violated, not the car's.
Yes. I mean, if they had stopped the car minutes after the road rage incident or minutes after the ticket agent incident, then it's a reasonable inference.
So I understand your argument with regards to the driver versus the car. What I don't understand is the staleness argument, because in terms of staleness, the car is the car, and there's no doubt that this is the car.
Right. But when you're talking about a 3-week gap, for example, we just discussed how it's the driver that has to be connected to the criminality. The car's connected to the criminality, but not, who knows who's driving.
So what is an officer's...
I'm sorry.
I'm sorry. What is the officer's responsibility? What can an officer do in a case where there is a vehicle that apparently is being driven, committing crimes?
Well,
officer comes upon this vehicle, hands up, they have to leave?
Of course not. And I'd like to talk about both this case and what happened in Lindsay, where Jones, I should say, where the officers did the right thing. In this case, the officers were surveying
Well,
this
in Jones,
car.
they went and they looked, right?
Yes.
They looked at the driver. They confirmed
Yes.
that it was the person. That's a
And
different
then
scenario.
they made the stop. Here, the officers had even more options because they were surveying and they intentionally chose to position their car so they didn't see who the driver was who got in. All they needed to do was confirm that the driver was an Hispanic man.
What about the facts, counsel, that they ran the plates, they knew who the registered owner was. They saw the car at the home of the registered owner where it was registered at. Doesn't that come into play in terms of reasonable suspicion?
That's not a reasonable inference that just because someone's a registered owner, you can assume they're driving the car.
Okay,
This was a minivan.
I got it. You get it on rebuttal. Thank you.
Good afternoon, Your Honors. Franklin Gunther for the people.
So, counsel, with respect to the BOLO, the be on the lookout alert that was placed on this vehicle by Detective Thomas, was there a time frame? Was it valid only but for so many days or so many weeks or months?
I think if not for the incident the day before, that might be the question before this court. But I think because of what happened the day before the stop, where the officers are responding to a call of the van driving away from a parking ticket and nearly hitting a traffic agent in the process, the officers then run the plates that are provided by the traffic agent along with the description of the car, and then they learn about the BOLO report, and they make a connection, a reasonable inference that those two things are related.
Well, let me stop you there, because I think we agree that it's more than reasonable that the car's connected, right?
Mm-hmm.
But that's all they have. So is it your position that because they connect the car to an incident that happened the day before, that in and of itself is enough for reasonable suspicion to stop the car?
Yes.
And if that's your case, give me a case.
Well, I don't know of a case where there is...
Neither do I.
Excuse me?
Neither do I.
I don't know of a case where there is a discussion of the exact car, but I think all of the cases that are cited by defense counsel, as Your Honor noted, it's a general description of a car. It's a car maybe of the same make or the same model, but a different color. This is the exact car that is...
But I think in the cases that counsel cites, there is a matching description of the driver, which makes it different, takes it out of this situation.
Well, I would note that the BOLO report does have... did provide a description of the defendant.
Okay, that may be true, but at the time of the stop, did the officers confirm the identity of the driver? Did they know who was driving at the time they stopped that vehicle?
They didn't, and that's undisputed.
Is that fatal?
What's that?
Is that fatal?
No, it's not, Your Honor, because again, the exact car is being used to commit two separate crimes on two separate
We know
days.
it's the exact car because the license plate's there.
It's the license plate connects the car.
You would have
and
a
the
problem.
car.
Hold on a second. You would have more difficulty if you didn't have a license plate. So that, you know, there are a lot of vans that look like that in the city of New York, but you have a license plate that attaches to this vehicle. So that's a clear, no question, this is the car that's involved in the two incidents.
It is the common thread between both incidents and is what ties the defendant to
your
both
friend
crimes.
is trying to make it so that the car and the individual driving it, who happen to be the defendant, is inseparable. That they all have to be viewed as together, so that the stop was not permissible.
I think, first of all, I think the rule from Hinshaw is broader than that. And just as a practical matter, I don't think it's reasonable to expect the police to identify the driver of a car every time they suspect that person of a crime.
So
And I think
counsel,
here,
it would seem that there's only three options. Either the driver was the person involved in the incident, the driver was someone who was given permission to drive the vehicle, or the vehicle was stolen.
that's correct. And I think because the officers have reasonable suspicion, they are allowed to stop the car and investigate whether the person who is driving that car has involvement in these two crimes, one of which took place the day before in the exact same neighborhood and is also
Counsel, I guess what I'm having difficulty here with is what the Fourth Amendment protects us against unreasonable searches and seizures, right? So we're talking about whether the police impinged upon the driver. That's who they stopped, right? The driver's Fourth Amendment rights. This is one of those cases where, as in Jones, the officers could have easily driven by the vehicle, made an observation as to who the driver was, and then made a determination. They opted not to do that. They just stopped the car. Whether that's reasonable or not, that's another story. But my point is, isn't the defendant's Fourth Amendment rights violated when they just stop a vehicle, although I want to say justifiably, in that definitely the car was involved in two prior incidents, but they had no idea who was driving it?
well, I think, first of all, when they first noticed the car, it is parked legally outside the defendant's home, and there's nothing they can do at that point. So, and I think what's critical for this court to remember is that
And they know it's the defendant's home, right?
What's that?
And they know that that's the defendant's.
They know that his address is registered to the vehicle, and they are in the precinct where the incident with the traffic agent took place the day before.
So do those facts go to the reasonableness of the officer's inference that he was the driver?
Yes, absolutely. And I think it's because, again, both of these crimes involved that precise car. So you need to confirm that someone owns this car and is getting in before you can make a stop, because that is the identifying characteristic.
So to that point, I view the body cam. I mean, the way the body cam footage in the case is that the officers approach the person, I don't know who it is, they approach the person driving, the driver of the car, and they ask for license and registration. And I think one of the questions was, are you the owner of the car, and do you let anybody else drive this car? I mean, that was the next. Those are questions or inquiries that seem to flow from what I believe was a reasonable suspicion to stop that vehicle, because that vehicle is clearly, unquestionably, the vehicle involved in the two incidents.
And the officer who asked that question testified at the hearing that was the purpose for asking that question. These are all this is all well within level 3, reasonable suspicion, investigative
Counsel, when the officers approached and noticed the driver, did they immediately recognize the driver as the person they were looking for?
Well, the record's not clear on that. I would note that the detective certainly had a description of the suspect. That is also in the
description was
book.
nothing more than a Hispanic male.
What's
right?
that?
The description, as I recall it, was nothing more than a Hispanic male.
That's correct. And I mean, the record's a little muddy on this. I will concede that, because the traffic agent, although he gives a description of the driver at the hearing.
There's a mishit for the traffic agent.
What's that?
There's a misidentification by the traffic agent, ultimately, correct?
That's correct. But he did identify him at the hearing. He described him as a Hispanic male at the hearing. Whether he relayed that information to the officers is unclear from this record.
Is it a reasonable starting point that you see a car that the most likely is that the person driving it is the owner of the car?
I think that's a perfectly reasonable inference. There is a very small universe of people who could be driving that car. As Your Honor noted, it's either the owner, someone who has permission to drive the car, or perhaps it's stolen. I don't think there's any reason to think, based on the conduct, there's no smashed windows or anything like that, to believe that the car is stolen. It's a reasonable inference that the person who owns this car is the one who is involved in both of these crimes.
Okay, thank you.
We ask that you affirm. Thank you.
it's an inference that because the car, granted, it's an inference that because the car is parked in front of the address and because this was the registered owner, maybe he's driving. It's not a reasonable inference. We're talking about New York City and we're talking about a minivan. People in New York City, a minivan is a family car. It's not a Ferrari where you can just assume that one person is, this is their prized possession.
Is it reasonable to say that the police know that a certain car, because they know the license plate, has been involved in a shooting? A few weeks later, they know, or maybe a little bit less than a few weeks later, they know that this van is involved in trying to run someone over. So now when they spot this van and they know that they're talking on the two prior occasions, it's the same van because they have a license plate number, that the police should not stop that van.
They should not stop that van until they take the extra step of getting individualized suspicion that the person they're stopping.
How do they do that?
In this case, they could have simply waited, watched to see who got in the car, and then.
The person's in the car already. How they going to be able to figure out who the driver is? I mean, what are they going to do?
Well.
Are they going to drive by slowly and look in?
Jones, that's exactly what they did. And in Lindsay, the second department counsel,
but in those situations, the car, it's questionable whether or not the car was the car, right? This is no question. Unless you're going to stand and say, this is not the right car.
There's no question this was the car, but that only gets you so far.
There's also no question that this car has recently been driven by someone who's armed and dangerous, and it's also been driven by someone who tried to run over a traffic agent.
With respect to the traffic agent, it's not that the record isn't clear. The traffic agent did not provide any description. There's no evidence that Mr. Zubidi was the person even in the car.
In my mind, there's two questions. Was the stop permissible? Was there reasonable suspicion to do the stop? And then what followed later when the police went to the driver and asked for identification? Okay, those are two separate, in my mind. I mean, there's no cases out there that talk about what we have in front of us now, because I know you're trying to tie the vehicle and the defendant as one universe, right? That they're inseparable. But I think on these facts, there might be a little bit of a separation here.
May I just take a second?
Sure.
Which is on this issue of the police going up asking for his name and his ID. Far from showing that this showed reasonable suspicion, it's the opposite. They needed to determine whether they had stopped the right person by getting his ID and asking.
Counsel, who you say stopped the right person? They stopped the right car.
But Hinshaw, it's not. It's not.
Car which had recently been involved in two very serious crimes, and you're suggesting that they shouldn't stop that car as soon as they possibly can?
I'm suggesting that the reasonable suspicion standard, when there's a gap in time, requires more than just the fact of the car itself. There has to be something tying the person whose liberty they're impinging on to the criminality, and they did not for stopping a car. They
I don't think,
stopped him on the
counsel,
street.
the way this plays out, I'm not sure that on this record here that they had thought or believed that the defendant was the driver. I think they stopped that car based on what I have in front of me, based on the fact that the car was the car that was involved in two incidents. What happened next is another level of inquiry that we have to go over, whether or not the Fourth Amendment, whether the defendant's Fourth Amendment rights are violated. But that said, thank you very much. Thank you both. Chry versus Terrace on the Park.
Good afternoon. May it please the court, Michael.
Hold on, so you got to wait for the other guy to get up here. You're starting without him getting here. The train didn't leave yet.
Okay, yes. May it
Hey,
please
counsel,
the
go
court,
ahead.
Michael Cassell for Sephora Chowdhury. As we explained in our briefs, this is a situation where my client...
Well, this is going to be interesting. The defendant that should be here responding to you, you're going to be, it's a one-sided, you're like, look, they put it up. They put the protection on, right? And that's it. Good story.
I mean, exactly. We have a situation where we're going to get to trial where he's going to argue, my colleague here is going to argue he's for Glenwood.
Yeah, it was them.
Exactly.
Your position is, I don't care who it is. My guy got hurt. The two of you fight it out.
I would also note just one more thing, Your Honor. Glenwood is a management company. The defendant who was let out is Cavco Roofing. This is roofing material. Just common sense in the world of construction.
Well, if we had common sense, we wouldn't have a lot of labor law cases.
I understand that, but you have to interpret all the facts in a light most favorable to my client. So maybe put aside common sense, but under the rubric of interpreting the facts in a light most favorable to my
To
client.
me, your client was just walking, going home, and gets hit in the head with a piece of wood.
Exactly what happened.
Come on, something happened.
So what is the evidentiary basis for keeping Cavco in?
We have Markowitz's testimony, and more importantly, we have a contract. A contract says Cavco Roofing is responsible for roof protection. They're responsible for the protection of its work. It's roof protection that falls off, and Markowitz's testimony, consistent with the contract, says Glenwood doesn't install roof protection. Someone else did. Cavco was the only contractor working on the roof. There's at least a question of fact. It's either Cavco or Glenwood. They should both be in the case.
Okay.
Thank you, Your Honor.
Thank you.
May it please the court, Daniel Kotler from Lester Schwab, Katz and Dwyer, on behalf of Glenwood and Terrace on the Park. I'll just add a few comments specifically about the third-party claims. My first point is, even if there was an Espinal bar to plaintiff's claims, which I agree with plaintiff that I don't think there is, but even if there were an Espinal bar, that wouldn't affect my client's third-party claims because my client has the contract. So they're not a third party to the contract. This is the contractual relationship, and that's directly where the duty flows. The other point is the court made a mistake when it looked at the language of the indemnity clause, which says arising out of the work, and said, oh, well, there needs to be negligence. This court has decided, and the brief cites the Guzman case, among others, which I know some members of this current bench were involved in that decision as well, where you have arising out of, unless it specifically says negligence, it doesn't require negligence. That's why contracts exist beyond common law. So with those points, unless the court has questions, thank you.
Thank you. Have a good day. Hudson Meridian versus Bayport Construction. I am recused from this matter, and Judge Friedman, you got the clock.
Good afternoon.
Go ahead.
I'm sorry. Good afternoon. My name is Daniel Katz here for respondent Hudson Meridian. There are really four discrete issues on this appeal. The first issue really relates to requisitions 9
Counsel,
and 10.
could you put the mic right in front of you?
Sorry. The first issue relates to requisitions 9 and 10, which the court below found that the parties agreed that appellant's claims were just limited to requisitions 7, 8, and 9, so therefore requisition 10 was knocked out and it's not part of the case anymore. The court below also found that the claims regarding requisition 9 should also be dismissed because our understanding is that the court searched the record and found the appellant did not make a sufficient record to defeat summary judgment, and the court on its own granted summary judgment, even though we did not actually move for summary judgment, but the court is empowered to search the record and make that determination. The second issue really has to do with unapproved change orders. The law in this department and all departments in New York, it's clear that on a construction contract, if you're doing extra work and it's a contract that says extra work has to be approved in advance by a signed change order, you cannot get recovery for that. And part of their claim here is for these unapproved change orders. To the extent their claims include that, that all should be knocked out. And the leading case, I think in this department, is the Garofalo case, where the court upheld the contract which precluded someone from receiving and getting paid for any work which is where there was not an approved change order. The third issue has to do with delay damages and whether or not our client can succeed in alleging delay damages against the appellant here. And we relied on a detailed affidavit by a fact witness who had extensive experience in delay claims and also extensive experience in CPM scheduling. And we also prepared and submitted an affidavit by a scheduler, an independent scheduler, who kind of filtered out the delays to show that the delays in issue were just related to the hoist materials, which is what the appellant is claiming for. So therefore, we think we've made our burden to show delay damages here. We've also submitted substantial documentation. I believe it's the exhibits W, X, Y, and Z, where we have various backup for these claims. So we think we've established that the claim for delay damages can go forward. I just want to point out to this court that occasionally the no damage for delay provisions would come before this court, and this is not a no damage for delay case. This is not a case which has a much higher burden to establish whether or not you're entitled to a claim. There is not a no damage for delay clause. This is a straight damages claim for delay, and we don't have a higher burden. And we're not moving for summary judgment on the delay damages. We just have to make the modicum of testimony and evidence to show that we have a claim for delay damages, which we believe we do here. I also shouldn't.
Thank you.
Okay. Thank you.
Yang versus Pagan Law Firm?
Meridian.
No, that's submitted.
Oh, this is submitted, okay.
May it please the court, I'm Sanford Young for the plaintiff defendant. One of the primary grounds of this appeal is that the defendant never met their initial burden on the summary judgment motion. Their motion consisted only of an affirmation of an attorney attaching a bunch of miscellaneous documents, self-serving notes, and other things of that nature. And it's best illustrated in the case against Dr. Asher Walsh. In the case of Dr. Asher Walsh, the defendant's expert, a legal expert, claims that Pagano firm made attempts to find an expert to testify or to give an affidavit as to the standard of care of Dr. Asher Walsh. And he refers to 2.5 pages of notes of contacts that the Pagano firm allegedly made.
Counsel.
19 experts were.
All right, counsel, I understood your appeal, this appeal, and correct me if I'm wrong, is that the argument here is the plaintiff was saying that she was forced or coerced to settle the case, right?
Yes.
That's the claim, the legal malpractice claim.
That's the claim against against the doctors Reese and Magatsky. That case was settled. But what happened was Dr. Asher Walsh, who was also sued.
No. I'm talking about this lawsuit against the Pagan law firm, the basis of that.
It's both things.
Okay.
It's their failure to oppose the summary judgment motion by Dr. Asher Walsh.
Right.
And the excuse that they make in their papers by their expert, Mr. Zuller, is the 19 contacts they made. Now, Mr. Zuller refers to an Exhibit V. And if you look at Exhibit V, which is these miscellaneous notes, you'll find that they contacted a number of people. But in many cases, there were maybe conflicts. There were cases where they couldn't reach people. There were cases in which they were supposed to call back people. One of the most interesting of those cases was a case of a Dr. Lawrence Lynn, who they contacted, and this is on page 881. And Dr. Lynn suggested to them that they call him, and that he will give them references, and he will explain things to him.
So permit me to digress a little bit to stop you because your time's running out. All that still boils down to the settlement, right? The settlement that
Does not.
You mean though? Okay.
They didn't settle against Asher Walsh. They didn't oppose his motion of summary judgment. So even though they settled,
The settlement doesn't wrap that in?
Correct.
Because they didn't have an expert to set forth how Asher Walsh had committed malpractice.
But they never met their primary burden as to that. They submitted the motion by Dr. Asher Walsh consisting of a notice of motion and the affirmation of his...
Why doesn't their prima facie showing, and I know you're trying to question that today, but why doesn't their prima facie showing that they contacted 19 experts?
I'm trying to get to that, Your Honor.
Yeah.
And I'm trying to explain in one case, as an example, Dr. Lynn said to them that, quote, he said those cases are like low-lying fruit for us waiting to be picked. He was offering to give them assistance to make a case. They didn't follow up on it. We don't have any affidavits or affirmations by anyone at the firm explaining why they didn't follow up. We don't really know that. All we know is that their expert uses a number 19 out of some miscellaneous notes that don't really say what he says they say. As for Dr. Asher Walsh is in the primary burden, Dr. Escher Walsh had an expert, but they didn't include those papers in their motion, the Pagano firm. All they included was the affirmation of Dr. Asher Walsh's attorney making references to what the doctor said. But if they were going to meet their primary burden, they should have put in at the minimum, the affidavit or the report of their doctor. So this all along, and I have the greatest respect for this firm, but this is a case where they did nothing to meet their burden.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court. Aaron Barham from Furman, Kornfeld, and Brennan on behalf of the defendant respondents, the Pagan law firm, William Pagan and Tanya Pagan.
So the focus here is that motion for summary judgment. That's if you heard your friend's argument today. That's the crux of this legal malpractice. I mean, I was trying to bring up about the coercion of enforcing the settlement, but the focus is the motion. So why do you think that his arguments don't prevail here?
Yeah, 95% of his brief was coercion, and I was prepared to talk about that today. I was also prepared to talk about breach of the standard of care and proximate causation, which really aren't mentioned in the brief already, and there's a litany
So
of...
why did you let Asher Walsh out?
Yeah.
So there were 19 experts that were consulted, and each of them said that they couldn't opine as to a deviation of the standard of medical care. I've never heard of 19 experts being consulted in a case. Usually
you get one, right?
maybe like 2 or 3. Like
Somebody's out there.
I talked to 3 experts. They all said, that the case wasn't viable. Okay, so we move on and we pursue the claims against Dr. Rice and Dr. Magatsky, who were the target defendants who performed the childbirth, and there was a vaginal tear and there was an episiotomy. So I think that they went way above, like they're all-stars in my opinion. I represent lawyers for a living, and I've never had a case with such favorable facts. 19 experts that were consulted. They try to make this technical procedural argument about admissible form. Everything was admissible. The documents we submitted would even qualify as documentary evidence on a 3211 motion. We're talking about emails between the parties, we're talking about court filings, and they were authenticated via an attorney affirmation, which is also proper procedure. The overriding argument, I think, in this case is but for proximate causation. That wasn't mentioned at all. I was stunned to see that wasn't mentioned in the briefs or during oral argument. This was a really...
What showing do they make for purposes of the motion that Asher Walsh did commit malpractice?
I'm sorry?
What showing, if any, do they make that Asher Walsh committed malpractice?
I didn't really hear what Asher Walsh did during opposing counsel's recitation of the facts. And they tried to obtain an expert opinion to go against the defendant's experts. They couldn't do that. And in medical malpractice cases, in summary judgment motion practice, you have to have an expert opinion. I know a little bit, I do Google research, to find out about, maybe these days you do ChatGPT, right, to learn about.
Online research.
You're right.
Oh, you can just say research.
We do research, but you need a doctor to support what the attorney says in an affirmation. And if you can't find a credible medical expert to give you that opinion, then you don't oppose the summary judgment motion. That's not something like that's ethical to do if you don't have the proper expert support.
So what about this coercion and forcing the settlement on the other side, the side that I thought was going to be a big part of this argument?
Yeah.
What's your response to that?
I think that we have really strong factual and legal precedent to respond to those arguments. That there's the precedent that says retrospective dissatisfaction with the settlement doesn't support a claim for malpractice. There's also the precedent that says the alleged violation of a disciplinary rule or ethical obligations does not generate a cause of action for malpractice.
I even go something simpler. Did this not happen that the plaintiff thanked the firm?
Right. So on page 1 of the brief, there's a gift basket.
Right.
And she thanks her for all of her personal attention to her case over the years.
The case ultimately settled for 1.3. It was the offer was 1 or something. The plaintiff apparently set a floor, a net dollar figure that she wanted. Then it came in at 1.2, where she still rejected it. but ultimately it was a 1.3, and that she took that.
Yeah, you'll notice on my brief, Your Honor, that there were several months of negotiations, and I put them all in bullet points. There were offers, demands that were rejected. There was a settlement conference before Justice O'Donoghue, where Justice O'Donoghue
But
was...
counsel, on September 15th of, I don't know what year it was, 2000, whatever, there's a back and forth where it's a trial date finally set, and the firm sends documents saying, here's the experts, here's our opposition, here's this and this, and then the plaintiff decides to settle, am I right?
Right.
On that very same day when a trial date is selected, what she apparently had wanted all along?
Right, she had, and this was going to Justice Ng's point earlier, authorizing a $1 million settlement. So they got a $1.3 million settlement offer.
Higher than what even the judge had said he might be able to
Right.
convince the other side to do.
Right, and so after expenses were cleared, and I see that my time is up, the plaintiff was able to pocket a $1 million settlement after expenses were paid.
Thank you.
The typical medical malpractice case, when there's a motion to dismiss the case on the grounds that there was no medical malpractice, you have a report or an affirmation from a doctor that is opposed. In this case, there was none.
So you don't have a report now which says that Asher Walsh committed malpractice.
Correct. But the burden of proof.
All that you're doing is saying their claim that they contacted 19 experts shouldn't be considered, shouldn't be given credence.
It's not based upon anything that's admissible, and I'm trying to make the point that it's not what they're saying. They're taking bits and pieces of documents that have no foundation or explanation.
They have an expert who says, look, they went to 19 doctors and they couldn't get anyone to say that Asher
All the
Walsh.
expert referred to was this one exhibit I'm referring to, Your Honor.
Counsel.
But you don't come forward with something which says, what are you talking about?
It's not
I've
our
got an
burden
expert.
to do that.
Well, if they
It's
made
only-
their prima facie, you do.
Right.
Let's assume they made their prima facie. What do you come up with, right?
I would accept that, but they didn't make their prima facie case.
I'm saying, well, okay. We're going
Now,
around in
I also
circles.
want to say that I chose a short period of time today for oral arguments, shortest I've ever chosen. I did not mean to give up the claim of the coerced settlement. I just wanted to concentrate on the claim against.
So, counsel, with respect to coercion and undue pressure, the firm, the defendants kept saying, there's a really big risk of going to trial here. You could end up with a defendant's verdict and lose completely. And nonetheless, the offer kept going up from $800 to settle to $900 to settle to $1 million to settle. And the judge says on September 10th of whatever year it was, look, I can probably get them to go for 1.2. On September 15th, and you heard me say this before, on September 15th, you get a trial date. And that's the day that she says, I'm in 1.3, I'm done. 3 years later, after she settles, after she sends the thank yous and the gift basket and everything else, 3 years later, she says, my attorneys, you were no good. I don't get it. What happened during the course of 3 years? Does the record tell us anything?
Continued suffering, but the point Judge Krause found that there was coercion, found that there was no explanation and no opposition given by that.
You tell me where the coercion was.
Coercion was that William Pagan, who she met for the first time and who forced her to take the settlement, said he would not want to try the case. She has to advance $30,000 for expenses that she does not have.
When was that said? When was that said?
That was said in the meeting, that she had with William Pagan.
I'm sorry, what date?
I don't know the date of that offhand, Your Honor.
Okay, thank you very much. Thank you. Thank you both. 318 West 15th versus 320 West 15th. Justice O'Neill Levy is recused from this matter. right, you're up.
Good afternoon, Your Honors, and may it please the Court. My name is David Pereno from Pereno-Malinowski for Appellant 320 West 15th LLC. My client is appealing the decision of the lower court to grant partial summary judgment for
On the strict liability issue, right? Saying it's all you, you're done. That's it.
That's correct, Your
And
Honor.
Based on this record here, even before you broke ground, there was some sort of report that said, you know, there's something not right here, and that they actually went and looked in and they saw the drain pipe, or am I getting my facts mixed up? Or
The facts are slightly messed up. We didn't discover the broken drain pipe until after the damages reports were made. However, Your Honor is correct in that there were more than a decade worth of evidence showing that there were settlement issues in this building of the very nature that the respondent plaintiff is complaining about in the case. And that has been our point pertaining to this, that my client's excavation is not the proximate cause of damages here.
Well, I think that their argument is that that vibrating hammer that you use, you know, the drain pipe may have been already fragile or an eggshell skull situation, right? And that your vibrating hammer actually sped up the crack in that drain pipe. I mean, that's their argument, right?
That is their argument, Your Honor. They are stating that they were mostly they were weakened, and we broke it.
Right.
And
but the flip side, your argument on the flip side is, if you knew about your eggshell skull and did nothing about it, and just waiting for us to come in and do something, you can't do that either, right? I mean,
that's part of our argument, Your Honor. That goes to really more to my counterclaims that your condition has prevented me from building a subcellar. What our real point is that we've had two different experts, one of whom was the acting chief inspector of the excavation and safety unit,
Who countered the notice of violation that was issued by his own people.
who removed the stop work order.
Who rebuked the essence of the stop work order.
That's correct.
Which said that the vibrations of the hammer caused the hazardous condition and created a possibility of collapse. So isn't that an issue of fact?
That is an issue of fact, and that's exactly my point. That needs to go before a jury. I have two extremely competent experts. They are competing experts to what plaintiff
And as this stands, this is a typical battle of experts. You've got Smith and Good against you, and you've got Volpe and Ismail on your side, and it would seem to set up an issue of fact.
I completely agree with Your Honors, and I think that what we've heard in response is that the prior conditions of the building don't matter, and there is no issue of fact here, which I completely disagree with. You cannot simply look at our experts and say that a reasonable trier of fact could not find in their favor.
Well, let's also go to the issue of the vibration monitors that you were supposed to, your client, were supposed to install at the building. I didn't find anything in the record that any vibration monitors were installed to track the possible expansion of the visible existing cracks that were found by the pre-construction survey. So can you address that?
Your Honor, there's no doubt that's a bad fact for my client. It's nonetheless one that needs to go before a jury. And I nonetheless have two experts that have seen these facts and have said, I understand. We did not perform vibration monitoring. Nonetheless, the vibratory hammer is not what caused these issues. We have more than a decade worth of data that show that these issues long predated my client's work. We also have the broken drain pipe, which has clearly washed away soils for more than a decade. We believe that that is the cause of damages here. And that
So with respect to the test pit logs that are in evidence, or in the record, I should say, they all indicated that there was loose sand, that basically the ground underneath the foundation was not stable, so to speak, and the photographs that are attached certainly raise a lot of questions about not only the failure to maintain, but also the decision to use something such as a vibrating hammer, which had such enormous force. We saw the movie that's part of the record. It was a very funny movie, but I mean, how many people do a Jurassic Park movie to show what the vibrating hammer can do? But nonetheless, it is a huge machine, and the work was done right next to the building. I mean, you could barely put a hand in between the two buildings.
Yeah, Your Honor, see my time has expired. May I briefly respond? So Your Honor, in response to that point pertaining to the soil conditions, one of my client's experts, Raymond Volpe, who has more than 40 years of experience, performed what's called dynamic cone penetrometer testing, and it looks at the relative soil densities of the soils, and he determined based on that testing that the soils on my client's property were relatively undisturbed. They were essentially undisturbed, while it was only the soils underneath the plaintiff respondent's property that were really severely undermined. And that points to exactly the basis for his conclusion, which is that my client's vibration-causing activity is not what caused the soil disturbance. It was the drainage
Sounds like apples
pipe.
and oranges, though.
What's that?
Apples and oranges.
That's correct, Your Honor.
Thank you.
Thank you.
Good afternoon, Your Honors. May it please the court, Daniel Horner for respondent appellant 318 West 15th Street, apartment court. Drain pipes don't cause damage, Your Honors. Reckless excavation and foundation activities do, however, especially when those activities are performed in contravention to approved plans from an SOE engineer who says
Did you start off by saying drain pipes don't cause injuries?
they do not.
If they're leaking for many years, they're not going to cause soil erosion?
All that does is demonstrate a condition. There was a pre-existing
You
condition.
got engineers that disagree with you. You got two engineers that disagree with you, unless you have an engineering degree.
No, I do not, Your Honor.
I don't either.
I mean, why didn't you've got two experts on one side, you've got two experts on the other side as to what the cause of the problems are here. Why doesn't that set up an issue of fact?
Well, what the appellant's experts failed to do is actually refute how the vibratory hammer did not cause damage.
Counsel, this is all backwards. I am floored by the allegations on both sides. I am floored by the photographs and the exhibits, the documentary evidence on both sides. You all didn't sit down to settle this. You're leaving it up to a court. That's on you. That's on you. But when you look at the pictures of the drain pipe, which is taking water from the roof down underneath the foundation, and it has a hole, like big hole, not a crack, a hole in it that's putting water underneath the foundation and washing away all of the dirt that's supposed to be underneath the foundation. Your remedy is a temporary fix to put a pipe that diverts the water into the backyard. I mean, what is going on in this building?
Well, that is a temporary remedy that had to be implemented
A temporary remedy that's been in place for how many years?
It's been in place for approximately 3 years, Your Honor.
Isn't that interesting?
Well, because when the ultimate repair of the building takes place, that's going to involve ripping up the entire foundation, at which point this drain pipe can be completely restored or replaced with a new drain pipe. But until the building can be restored in its entirety, this temporary diversion remains in place and is not causing any damages either.
I mean, you're going to have to prove at trial. If I agree with your friend here that there's a factual issue, you're going to have to prove at trial that this drain pipe had no hole when these folks started their business, right?
I actually disagree with that, Your Honor, because the building code...
What are you going to have to prove?
The building code places the burden on the developing party to do the exploratory work necessary to...
So let me take that, let's take that notion. At trial, they proved with their experts that this drain pipe was fine, when they whatever, but then when they, just before they start their work, something's happening already, that their work wasn't the reason why this drain pipe all of a sudden developed a hole in it.
Well, I don't even think they believe that defense, Your Honor. You have an admission from the 320 West 15th itself stating, surely our use of the vibratory hammer contributed and made what was bound to happen faster.
But that's true. Let's take that point. If that is true, if you knew ahead of time that you had something wrong, I mean, that's something they're going to have to demonstrate, because obviously if they have to take the condition as it is. But if you knew ahead of time that you had something was up with your drain pipe and you did nothing about it, you can't shift the entire liability upon the developer now, right? There's a shared responsibility there, isn't there?
I disagree, Your Honor, because I think that's the specific purpose of 3309.4, which Your Honor recently ruled in 711 East 13th Street Tenants Court versus New School, that it places an absolute obligation on the developing party to preserve and protect adjoining structures.
So you posit that you're going to be able to show that this drain pipe was not affected in any way by age or corrosion, and therefore you have a straight win here.
I don't think I have to demonstrate that, Your Honor. I think that it doesn't matter. I think that it's the burden of the developing party to determine whether or not its work that it intends to do will cause damage or not.
You know, the way this is teed up here, to me, Supreme Court agreed with your expert and did not agree with the appellant's expert. That's picking one side over the other. I mean, that's kind of extreme, don't you think?
It was consistent with the DeFuist versus Friedland case, where the defendant's experts failed to actually refute the damage-producing work as the cause of injury. The experts' reports were conclusory and, in summary fashion, failed to refute that. So,
okay, I got it. Thank
my
you.
time is up, Your Honor.
Thank you.
Thank you.
Stone, Core, and Shell next. Are you going to yield your time? Yeah, unless you don't want to argue.
No, it's just the ordering's a little weird. Sorry, Your Honor.
Yeah. No, I'm just identifying who you are.
Oh, sorry, Your Honor. Pat O'Donnell from Harwood Lloyd for Stone, Corn Shell, the defendant respondent. The cross appeal against Stone, Corn Shell involves their supervision, or their alleged supervision of the construction and excavation going on at 320 West. Plaintiffs alleging that Stone, Corn Shell was more than just a consultant, that they were actually the general contractor at the time, but that's just simply not true. Stone, Corn Shell was hired as a consultant. They were still on as a consultant. They were still working on post-appeal amendments, which go on throughout the course of construction. They were still looking for surveyors, things along that line in accordance with the contract. Plaintiff also argued in their 318.
Yeah, so essentially it's like there's factual issues as whether or not you should even be liable.
Yeah, it's a strict liability argument.
Strict liability. The court didn't grant strict liability against you at all.
No, we're just responding to their appeal regarding the strict liability issue.
Okay, got it.
Thank you.
Thanks. Okay, you're back up.
I do just want to briefly respond to what the DFAW East case says. In that case, the appellate division found that the expert reports could be disregarded because this quote-unquote lacked an evidentiary basis. Here, that is anything but the case. You have two different experts with 40 years of experience that outlined specifically the scientific processes that they went through. They reviewed all documents on site. They visited both sites. With respect to Mr. Volpe, he conducted dynamic cone penetrometer testing. With respect to Mr. Ismail, he was the acting chief inspector of the excavation and safety unit.
Let me turn your attention to something else. What about your cross motion for summary judgment to dismiss the complaint because the damages weren't alleged, or there wasn't any damages in this record here that you went forward after discovery, and then all of a sudden in opposition you get a new report on damages from someone a newly retained expert, and like, where'd this come from?
Yes.
In response to your motion for summary judgment to dismiss.
Yes, it was very frustrating.
Okay.
And that...
We didn't know about it coming.
No, we did not know about it, and Respondents' Counsel acknowledged that we did not know about it or that it was coming, and because of that, the trial court awarded us the costs that we incurred for the cross motion.
You wouldn't have made the cross motion to deal with.
It certainly would have been. I wouldn't have made that cross motion, and probably none at all. So in that regard, it was absolutely proper to award us our costs. Last thing I'll say is there is
Can I ask you about the party wall?
what's that?
Party wall. To what extent is there a party wall between the two buildings? Is it only with respect to what's underground, or is it the new construction?
I believe it goes up to. I believe it goes from foundation up to the fourth story of the properties. I believe that plaintiff's property is 4 stories, and it goes up the entirety of it. And with respect to that issue, what's the context of your question? I guess, yeah.
Collapse. I'm trying to figure out in my head if there was a collapse, whether that party wall would be sufficient to support 318, since there was a bulging wall found in the rear garden at 318.
That's right, Your Honor. Listen, we have we have evidence that shows that for more than a decade, the soil has been washing away. I think that goes to the bulging cheek wall issue. We frankly do not know right now the condition underneath the party wall. I can't sit here and tell you anything about that.
Leave it up to the engineers to figure that one out.
That's right, Your Honors.
Thank you.
Thank you very much.
Thank you. So why were the fees awarded to them on their cross motion inappropriate?
Well, the cross
Brought in a
motion,
new report, right? A new expert, new report. Where's this coming from?
so it actually was disclosed to them previously that we were working on a new report, and it came out through subsequent motion practice that our expert, who we had been relying on, Mr. Crosis, he recused himself.
That's fine.
So we had to get a new expert.
Yeah, I don't think that's a problem. That's not, I don't think the court even took that. I mean, whatever arguments you raised, I think the court looked at it and said, okay, you know, it is something that you can't strike it because it goes to damages, but you know,
So their motion was that even on Mr. Necrosis's report, we somehow failed to establish that we had damages. But Mr. Necrosis's report in of itself was sufficient to demonstrate that we had some damages, some measure.
But I think Judge Ung's question is, and it's my question, why is the award of costs per Part 130 inappropriate?
Well, the cross
Unless you
motion
agree that
itself
it
was
was.
untimely.
What's that?
The cross motion itself was untimely and should not have been considered in the first place. It was filed.
all right, get over that hurdle. Get right to the merits to it. Why do you think it was wrong?
The motion should not have been considered. It was untimely. And 2, the motion lacked merit in the first place because Mr. Necrosis's estimate did show some quantum of damages.
So if that's the case, then you could have just relied on that. Why'd you have to bring in the new report and new expert?
Well, I mean, why wouldn't we? We want to be as thorough
Well, why
as
wouldn't you?
possible.
Because now you see, looking back, and you see that they say, wait a minute, we didn't know about this.
I mean,
We
it
wouldn't
was
have made the motion if we knew about it.
Right.
in the spirit of trying to be as thorough as possible to oppose a dispositive motion. That's why we, presented the expert report that we did.
Okay.
With respect to the cross appeal, I'll note that StoneCorp was certainly not just a consultant. If 320 is strictly liable, StoneCorp is also strictly liable. StoneCorp was the one that pioneered the use of the vibratory hammer, went out and selected those means and methods which were in contravention to the approved plans for the installation of these sheet piles. Again, those plans,
They selected, or did they just research it?
he researched it, he proposed it, he was the one that advanced that use. He went out and found the contractor from whom they rented the vibratory hammer. He really was the architect of that instrumentality. So beyond that, he's also admitted to supervising the work, to directing the work.
What's the basis of direct liability against StoneCorp then?
The case law is clear that under 3309.4, any party who directs the work or supervises the work is liable alongside the owner. So he certainly displayed the hallmarks of what a general contractor or construction manager does, and there are numerous cases, including the D. Fouist case, that say that a construction manager is strictly liable alongside an owner.
Okay, thank you.
Thank you.
You both, thank you, everyone. People versus Jacob Leon. Okay, you're up.
Thank you. Good afternoon. My name is Danielle Bernstein from the Legal Aid Society, and I have the privilege of representing Mr. Jacob Leon. Mr. Leon had never been arrested, let alone convicted of a felony, when he was sentenced in this case. A lot of mitigating circumstances led to that aberrational moment in his life, and all we're asking this court to do is exercise its inherent power to take a second look at the sentence he received and make a modest reduction to get him out a few months earlier so he can rebuild his life. Now, there are several factors that support a more tailored sentence here, and I'd like to begin with...
What did the co-defendant get as a sentence?
Your Honor,
Co-defendant was not the shooter, right?
the co-defendant handed Mr. Leon a gun in this case. He did get more custodial time than Mr. Leon did.
Got 7 to 5, I think, on my notes here.
Your Honor, the circumstances of the
Your
co-defendant...
client got 4 to 5, correct? 4 years, 5 years PRS. Co-defendant got 7 years, 5 years PRS, correct?
That's correct, Your Honor, but we don't have the facts underlying the co-defendant sentence in the record here.
Your client was the alleged shooter, right?
That's correct, Your Honor. He was convicted, however, of criminal possession of a weapon in the second degree.
You're talking really fast.
I apologize, Your Honor. It's important when doing this review to look at the actual crime that he pleaded guilty to. That's, required by the criminal procedure.
Why is the waiver not valid?
For several reasons, Your Honor, beginning with the fact
All you
that...
just need is one.
That's true, Your Honor, so I'll give you one.
Give me one.
The court indicated to Mr. Leon that he would not be entitled to appointed counsel for purposes of his non-waived issues should he seek appeal, and that was repeated also in the written waiver. That alone vitiates the waiver. But there are other issues here as well, and it's important to consider this in the context of Mr. Leon's circumstances, right? That's what Seaberg and its progeny require. Mr. Leon was a first-time offender, had never been in court, was very young, and had severe mental illness as a history in his life. And considering the totality of his circumstances, his age, experience, and
He
background...
was 25 at the time of the offense, wasn't he?
That's correct, Your Honor. To me, that's young, but maybe not to the rest of the panel. But regardless, again, it's his first-time offense. He has no background in court. This is the kind of colloquy that requires...
There's no question he was told he was waiving his right to appeal the sentence.
Well, certainly that's the minimum requirement, Your Honor, but the appeal waiver colloquy still has to be accurate in all the other ways. If I may just turn to the merits again, if there are no other questions as to the waiver, I want to emphasize Mr. Leon's mental health issues as part of our request for a reduction here. It's well established in social science, and this court has credited as recently as 2 days ago in People versus Griffin, that people do better in their mental and physical status when they're in the community. And if they're in prison for longer than necessary, it can start to hinder their ability to stay on a better path mentally.
These issues raised before the court as far as his mental health?
Your Honor, it doesn't need to be for this court to consider it now as a mitigating factor.
But are you answering my question?
Your Honor, his mental health history is part of the record, absolutely. It was in the pre-sentence report and discussed as part of the negotiation.
Could that account to the reason why he got 3 years less than the person who handed him the gun?
Well, Your Honor, we just have no information about why the co-defendant got the sentence he did. But in terms of whether he got, a better sentence than he would have without the mental health issues, that's certainly possible. But again, it doesn't cabin this court from considering his circumstances. And there's information between plea and sentence that's relevant to that. Mr. Leon got on the correct medication for his needs.
You have to slow it down.
I apologize, Your Honor. The white light is amping me up. He got the medication he needed in between plea and sentence, which is part of the record here, but not something that was taken into account in that sentence. And
Did the defendant tell probation that he has homicidal ideations?
he did, Your Honor, and that's part of what led to this aberrational, incredibly serious offense. And that's also why...
You also argue his employment history, but isn't that employment history only a matter of 4 or 5 months' employment before the crime?
May I answer, Your Honor? That's all that's noted in the probation report. There is more than just what's within there. And I also would like to note for the court that actually when he gets out, he has a job waiting for him from his uncle and aunt who are watching right now.
Thank you.
Okay, thank you.
May it please the court, Rafael Corbello for the people. The appeal waiver here was valid. My adversary points to the notification by the court that defendant would be entitled to appellate counsel on appeal, and that's also spelled out in the written waiver. And both the oral colloquy and the written waiver go on to say that even though the defendant is waiving his right to appeal, he would nonetheless be permitted to raise certain issues on appeal. There's certain issues that survive.
At no point did the court say you weren't going to get appellate counsel.
Correct.
Okay.
Correct.
It may have used imprecise wording, but that was clear that appellate counsel would be provided. At least that's my reading of the
Right.
transcript.
Both the oral colloquy and the written waiver make it clear that the right to appeal comes with the right to appellate counsel. And so when the court or the written waiver go on to say that, nevertheless, notwithstanding your waiver of the right to appeal, you can still raise certain appeals that survive the waiver, that does nothing to change the nature of an appeal. There's no reason to think that the right to appellate counsel somehow would not be attendant to those kinds of claims that survive the waiver.
Counsel, did he face up to 25 years in prison?
He did, Your Honor, because he was indicted for attempted murder in the second degree after having fired several shots at another individual. And he availed himself of the people's offer to plead guilty to criminal possession of a weapon in the second degree in exchange.
And you had a video of this.
It was on, yes, a video, and he admitted. He also admitted it, that he shot at the guy because he was angry. He said the guy had robbed him earlier. So there's no question that he shot at the individual. And the reason why defendant's request for a sentence reduction is modest is because he got a very low sentence to begin with. And unless there are any other questions, I ask that you affirm.
Thank you, counsel.
Your Honors, as to the waiver, this court is, and opposing counsel is suggesting an inference that, maybe all of us as law graduates might make, but someone who dropped out of high school in 10th grade and had never been in court before can't be guaranteed to have made. When a court says to him, you would normally get a lawyer, you're waiving your right to appeal.
Well, you also don't have, you have to also put within that argument there that he did have counsel at the time, correct?
Yes, Your Honor, but this court has held over and over again that we can't defer to off-the-record conversations with counsel as a replacement for an oral colloquy or a written one. And just turning back to the equities again here, I think the court's decision a couple days ago in Griffin is really instructive here. This is someone who, at the time of this offense, was not getting the mental health treatment he needed, despite seeking it out several times in his life and requesting it for his time in custody. He now has the correct mix of medication to help him prevent something like this from ever happening again. Mr. Leon certainly does not want to reoffend, and I think that speaks to our shared goal here. This is a shared goal.
Thank you, counsel. Okay, thank you both. Londell Davis versus Joshua Clennon. Hey, you're up, counsel.
Good afternoon, Your Honors. Bernard Mitchell Walter, Alderman Barbaro for the appellant. Your Honor, this is a very simple, on the merits, this is a very simple election appeal.
Before you get to the merits, are you out of time?
No, I'm not, Your Honor.
Are you not out of time? The ballots have been printed already. They've been mailed. Court of Appeals set deadlines, and you've blown all those deadlines.
What am I supposed to do about that? The guy got kicked off the ballot. No, hold on, let me finish on this. If you take a look at the case of Foxman against Cole, the courts have said the Board of Elections, even if it's inconvenient, should be forced to reprint the ballots. This is an assembly. We're not talking about a county race. We're talking about a single assembly district. We're talking about one single assembly district. The board is not inconvenienced for reprinting these ballots. And what happened was—
Isn't it more counsel than reprinting ballots? Isn't it a question of probably having to delay the primary election in this district?
No, not at all. In that Foxman-Cole case, the Appellate Division's second department issued a decision the night before the election, and they told the board, go out and reprint the ballots and have the race the next day.
But here we have—
I was going to say, was that before we had mail voting, mail-in voting, all that
absentee ballots, military—
No, absentee ballots.
Counsel.
Absentee ballots.
Counsel. Hello.
Sorry, Judge.
It's okay. What about the absentee ballots and the military ballots?
In that race, there were absentee ballots. Absentee ballots have been in this state for 100 years, so the absentee ballots were already out there. So we're going to lose. I'll admit.
Okay, let's turn to the merits. Let's get to the merits.
I'll admit. Let me answer your question, Your Honor, if you don't mind. I'll admit they were not on the absentee ballots. I'm not concerned about that. I'm concerned about early voting and primary day. And they have plenty of time to reprint the ballots for early voting and primary day.
Okay, so let's turn to the merits. Why do you think on the merits Supreme Court was wrong?
Very, very simple, Judge, and I can tell you this in 2 seconds. The referee had a hearing. The referee made a determination. She said you didn't prove anything regarding the subscribing witness's residence, It's your burden of proof. You failed to show any evidence that this man did not have the two residence cases, and you lose. And he said, there's nothing in that record that would indicate to me, the referee said this, that you have a right to reverse the referee's opinion.
So the way I understand this record, because it came to us in like within 24 hours, that the individual that we're talking about here, Mr. Joshua Clennon, has a voting card address, a voting address,
Correct.
right, which puts him in one area, one election district, and a resident address in another area, correct? So he had two
Yes,
addresses.
No, he claimed he was living. No, it's not. He claimed he was living at another address, and his voting address was at another address.
What? Say that again?
In the testimony on the record, which you have in front of you, indicated that he had a voting address at one location, and he was living in another location.
Okay, and he put down the voting address as his residence on the designating petition.
Correct.
Okay, so in my mind, yeah, you can have multiple residences, right? You can have whatever you want to do. But in this case here, there's the fact that it's a voting residence versus an actual residence where he actually lives and goes to and sleeps at night. Does that make a difference?
Judge, as long as you have a connection to that voting address, it could be your mother's address. If you look at Gallagher again.
I'm not talking about, the statute doesn't talk about, make a distinction between voting address and not a voting address. The statute just says residence, correct?
Residence can be multiple residences.
Oh, yeah, that's right.
And if you look at Mayor Bloomberg, he's got residences all over the
Well,
world.
I don't know if we got Bloomberg involved in this case, right?
One I know is down in Wellington. He's got this big dude ranch down there, and his voting address is here in New York.
Right. We're concerned about your client.
No, you're not concerned. My client's not the issue. It's a subscribed witness.
Oh, I'm sorry, that's right. It's a subscribing witness.
The subscribed witness came in. He said, I now live at such and such an address. And this was a month after the petition was signed. You got to remember, this is a month later, so we don't know what he was doing a month earlier.
Well, that's the thing. You know, the transcripts, when I'm looking through the transcripts, it didn't really explore exactly where he's living. I mean, they just asked him about the two addresses, and that was it, and he moved on.
Right. The question, that's exactly right. And the burden of proof, you take a look at that case, the court case, the burden of proof to prove that that person did not vote at the address he sets forth is on the respondent, not on the appellant. Court says that.
Assuming that they carried their burden, wouldn't have been, I mean, I presume you were there at the hearing.
I didn't do this trial, Judge.
I'm sorry?
I did not do the trial.
You weren't at the hearing.
I'm
You were
the
not.
appellate
Oh,
lawyer.
you were not representing him at the hearing.
That's correct.
That's okay.
Now, Judge, the point is, the referee held you didn't have enough evidence to take the subscribed witness off the ballot. It's your burden, meaning the respondent's burden, to show that you didn't have that person didn't vote at that address, okay, and didn't have the right to be at that address. And if the record is completely barren about the two residences situation, since the burden of proof is on the respondent and not
Well,
me.
if the record is barren on exactly where his residence is, that doesn't do well for the subscribing witness.
But the point is, who's got the burden of proof? The subscribing witness says, I voted such and such an address.
You have rebuttal time. Thank you.
Okay.
Good afternoon. May it please the court. Paul D. Newell for respondents Davis Jr. and Wright.
So we have the subscribing witness, and he puts down on the designating petitions his voting address. Okay, he has another address that's his resident, and you know, I don't think there's any argument here that there's any sort of wrongdoing going on. I mean, everybody can have multiple residences, but the fact of the matter is the designating petition lists as an address his voting address, and there was no testimony exploring whether or not that voting address is his actual residence, because the statute calls for residence.
Correct. In fact, there is testimony, specifically a judicial admission under oath by the subscribing witness at issue, Mr. Justin Green. I reside at, and he said his residence. He also said
Another address. It was he reside at the other address,
at Commerce
not
Avenue.
at the voting address.
Correct. He said, I reside at 1332 Commerce Avenue, and he put on the petition Bronxwood Avenue. And while counsel is correct that it is for qualifications issues of, you know, candidate residency, and these are all the cases he cites in his brief, and also where you can vote from, a person may have multiple residences and if they have ongoing relationship with a given address, they can continue. That is not the case. That is not the issue here. This is about the residence address of the subscribing witness, which all of the case law from Pisani v. Kane and onward show is about subjecting the subscribing witness to subpoena. And we have explicit testimony from a member of the campaign, which makes it a judicial admission, as well as an uncontested statement of fact under oath, that Mr. Green's address was on Commerce Avenue, not Bronxwood Avenue, a good 2 miles away, and had my clients wanted to subpoena Mr. Green at the address on the petition, they would have failed because he does not reside there. And that is the purpose of Section 6132's requirement of the actual residence address.
So can you clarify, my notes, I got to get this straight. I want to make sure I get this right. Where was he registered to vote? Bronxwood Avenue?
Correct.
Okay, that was his registered vote. His residence is at Commerce Avenue.
Correct, Your Honor.
Okay, I just want to make sure I got that. Okay.
Correct. And you know, if you look at the case law, Henry v. Trotto, cases where you have the subscribing witness testify under oath, I reside at an address that is different from that on the petition, that meets the objector's burden, whoever is objecting to the signature's burden, at least on a prima facie level, of to show that that's not the address. Now, it is true that it is possible to show they didn't establish another permanent address and they were just dislocated because of construction, but the idea that it would be the objectors, or in this case the petitioner respondent's duty to fish and ask on cross-examination, which was not provided in this case, but for just to search around for whatever that connection might be. Clearly, in every case where that has been rebutted, that prima facie showing of a different residence has been rebutted, it has been evidence presented by whoever the proponent of the petition. And that can be done, and it is possible. In the case of the subscribing witness, it's not just I have continuing residence, you can't have established another residence, so that the residence on the petition is the best place at which to serve a subpoena. Because again, it's not about qualifications. Mr. Green would have been qualified to witness the petitions from Rochester, New York, or from any address in the state of New York. The correct address is required on a subscribing witness's statement because they must be subject to subpoena in an Article 16 election law matter.
And you're saying that the timetable that the Board of Elections put forth really isn't the issue, right?
Well, no, I also stand on the fact that appellant's requested relief on appeal is impossible to grant. The board has obviously outlined that in their brief. I do want to address, he cited a case, counsel cited a case, Faulkman v. Call, which is a 2017 case, Second Department, regarding a Nassau County legislature race. In that case, the primaries were in September in those days. It was September 12th primary. The Supreme Court removed Mr. Call from the ballot on September 12th, 10 days before the primary. On September 2nd, apologies, 10 days before the primary. The ballots were already printed. His name was on the ballot. He was on all the absentee ballots. They had just reprogrammed the machines, the optical readers, to not count his votes between September 2nd. On September 11th, the Second Department reversed that. So the board, this is the Nassau County Board, did have to reprogram the machines, which was a serious undertaking, but there was not a reprinting of ballots, which obviously the day before the election would have been impossible. And as the Board of Elections has clearly stated and unambiguously stated, is impossible here.
Great, thank you.
Thank you, Your Honor.
Judge, the respondent makes an issue of the subscribing witness being subject to subpoena. The subscribing witness happened to be in the courthouse being called by the candidate because there was an issue about alterations on the petition. So the issue about subpoenaing the subscribing witness is irrelevant because the man was sitting there right in front of him and subject to cross-examination by the objector who did not take the opportunity to ask him one question. Now, the other issue, Your Honor, regarding the ballot printing, we are talking about 2.5 weeks to go before the election. The Board of Elections can clearly have the opportunity to reprint the ballots and go ahead and do the election. Now, something's been said about my bringing this appeal up. I was blocked by two court. I'm obligated under CPLR 5526 to submit a full transcript of the entire proceedings. This trial lasted for a week and a half. I had to procure all the minutes, and I did this within the period as quickly as I could, and one court reporter went on vacation, and the other court reporter was slow in giving me the edits. And I worked like full-time, round the clock. I was writing this brief in pieces to get this thing in, and we did it as quickly as I possibly could. So the Board of Elections has plenty of time to reprint this ballot. 2.5 weeks is plenty of time. They can easily retool the machines. I'm not talking about absentee ballots. I'm talking about the early voting and the election day. Now, the subscribed witness was sitting there in that courthouse, and not a question was asked of him by the objector as to what the residences were. We're not obligated to prove his residence. He said what his voting residence was. The obligation is on the objector, and the objector had the person sitting in front of him and did not ask one question of that subscribed witness. All he said was, okay. And the referee made it very clear that the objector did not submit the burden of proof, failed to show the burden of proof, and therefore the referee did not requested that the application be denied. The judge overruled him. The judge overruled her, I should say, by saying that the two residences are there and he had a different address, and therefore he's off. Now, the delays on this appeal were not mine. They were subject to two court reporters, and you can see in my reply brief what I had to go through to get this thing done. 5526 of the CPLR says, I've got to give you a full record. I can't go up here without a full record. There were 5 court reporters over a 6-day period. You have all the record. You've got every piece of paper that I could find on this case. The entire record has been reproduced. Number 2, the Board of Elections has 2.5 weeks to go. They can easily reprint the ballots. There's no issue on this. Number 3, the subscribed witness can have 2 residence addresses. Everybody has. Many people have different residence addresses. He said his voting address is in one location, and the other, when he testified, he said he's living someplace else. That's okay. There's nothing wrong with that. He swore on his petition, I voted from such and such an address. Nothing was in that record to indicate otherwise. It's not our burden of proof under the court case. It's my adversary's burden of proof. And I feel also that the Board of Elections in 2.5 weeks has got plenty of time to redo this election.
Thank you, counsel. Thank you for your...
Okay.